Let me see. Yes. I think they switched my people out at the jail. Wayne County Division 1, what's your name?
Hey, John Boyer.
Okay, thank you. Mr. Tipton. Right here. I can call that one real quick. Calling parties on Boyer. Case number 2159581. The people of the state of Michigan versus Majan Boyer. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. This is scheduled for probable cause conference.
Thank you, ma'am. Let's hear it, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning.
Good morning, Danielle Cataray, P77162 on behalf of Nathan Boyer.
Good morning, Cataray. Is your client present?
Yes, I believe that's him on Zoom in the jail.
Okay, Mr. Boyer, can you please state your name?
Good morning, John Boyer speaking.
Good morning to you. Okay, we are here today for PCC. What is your pleasure, Madam Defense?
We were here on Monday, if you may recall. I don't have discovery. The prosecutor didn't have the file. I was trying to argue for a personal bond. Mr. Boyer has a $15,000 10% bond that he cannot afford to pay, but you wanted us to come back. Once we had discovery, I still don't have the discovery though.
Mr. Bloomers?
I don't know where the file is, Judge. I have looked everywhere there is to look. I have emailed everyone there is to email. I have now had to resort to emailing the OIC to get them to scan me everything in their jacket. This file was cleared victim witness on July 16th and has since completely vanished. So I have not been able to provide that discovery to Ms. Cataray, or I've been able to look over it myself.
Wait, I didn't hear the last part. It broke up a little bit. You said, nor have you been able to review it yourself?
Correct, because the file is simply not anywhere.
Okay, so here is the issue though. Ms. Cataray, and rightfully so, is wanting to argue bond. And without having anything before her, that puts her in a little bit of a position to make an argument. So were you able to actually, you said something about scanning something.
Well,
I emailed
the officer in charge to request that they do it, but I haven't gotten that back yet. So no, I don't have even an investigator's report.
And is that unusual? Shouldn't there be something that's tangible that you could forward on?
I would say it's not the norm, but it's more common than it should be, that files are not present and available to the APA at the first PCC. I don't know what the issue is. Like I said, this file was in existence on the 16th when it was typed and cleared victim witness, and then somewhere between, and I don't know where it's been since July 16th. So I've looked everywhere in the file room. I've looked everywhere that it could be outside of the file room, and I've emailed the everyone on the central discovery team, which is one process that it does go through before it gets to me. I cannot find this file. So I aware that the court has a copy of the investigator's report, and if the court could scan that and forward it to both of us, I think we probably at least have sufficient material to argue bond.
That would be great. Madam Clerk is going to do that right now. We're going to recall it in just a moment. And in the interim, let me just also ask, I'm assuming the answer is no, but have you had any contact with the complaining witness?
Yes, I did speak with the complaining witness. Their contact info is in our computer system.
Okay, and did you gain any perspective on?
Yeah, she made it clear that she does not feel safe if he is released at all on personal bond. And that's her stance. So
Okay, now that is helpful information because I wanted to make sure that you had an opportunity to get in touch with your complaining witness. Madam Clerk is forwarding over what she's got, what was in the file here. And I want both prosecution and defense to have an opportunity, unless you want to argue without it, she's forwarding that over right now. And then we can recall this matter.
Thank you, Judge.
Thank you.
Calling parties on Watkins. Case number 2159609, the people of the state of Michigan versus Tremaine Richmond Watkins. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder. Count 2, domestic violence. This is scheduled for a probable cause conference. And Judge, I didn't receive this file. I just have an article.
Thank you. Let me ask you this, on this key one of books, why do I have this up here? Did we not finish one and not give it back to you from yesterday? Because that was the case from yesterday. Is that the exam we started with Mr. Jones?
It was.
Okay.
Let me look it up and see.
Okay.
Okay.
And you know what, do I have my notebook in there? Oh, no, I got it. So that was adjourned to August 6th, I believe.
I believe so, but I'll look it up and then I'll get back to you.
Thank you. People versus Watkins, can I have appearances, please?
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. May it please the court, P number 69160, Regina Triplett on behalf of Mr. Tremaine Watkins, who's present by Zoom. Mr. Watkins, state your name.
Tremaine Watkins.
Thank you. What is your pleasure, Madam Defense?
Your Honor, I don't have any discovery. We'd like discovery.
Mr. Bloomers?
I will get discovery forwarded to defense.
You need my email? You want me to put it in the chat or something?
If it's in the bar journal, then I shouldn't need it in the chat. If it's
Okay,
bar.
it should be, yeah.
Ms. Triplett, would you like another PCC or did you want to set this for an exam?
Judge, I do want another PCC, please.
Okay, so about August 27th?
27?
Yes, that would be a Friday.
Oh, yeah, Judge, I'm sorry. I'm traveling from the 27th to the 30th. I do have a trial on the 25th, but I can make myself available any other day in August.
Okay, what about August 26th?
August 26th? Is that what you said, Judge?
Yes.
So I'm scheduled for a jury trial in 36 on the 25th.
What about the 25th?
23rd, Your Honor?
Yes, ma'am?
Yes, that works. We'll be here.
Perfect.
Thank
I
you.
do find good. Great, you're welcome. To grant that new PCC, the new date will be August 23rd, giving an opportunity for that discovery to be tendered and reviewed by yourself as well as with your client. So, Mr. Watkins, I'll need you to zoom in as well on that date as you did today. And is there anything regarding
Nothing
bonds
further.
that?
No issues regarding bonds from the people. The people are satisfied at this time, Judge.
Okay, thank you. We're all
Thank
set.
you.
Thank you so much.
Thank you. You'll have a good one.
Too.
Calling parties on Gardiner. Case number 2062617, the people of the state of Michigan versus Sean Kareem Gardiner. The defendant is charged with count 1, weapons, firearm, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons, carrying concealed. Count 4 and 5, weapons, felony, firearm. Habitual offender, second offense notice. This is scheduled for preliminary exam.
Thank you, ma'am. Appearances, please.
Requesting permission to practice. Sam Weiser requesting permission to practice under MCR 8.120 under the supervision of Bryn Bailey, P84009.
Thank you. Granted.
Quinn 269483 appearing on behalf of Mr. Gardner, who I believe is appearing via video conference.
Good morning to you, Mr. Quinn. State your name, Mr. Gardner.
Sean Gardner.
Thank you. Okay, today is the date and time set for a preliminary examination. It was set for 10 a.m. It's currently 9:29, and I noticed we're calling it in advance of start time. Why is that?
I've had a chance to talk with Mr. Gardner about his right to hold a preliminary exam, and he wishes to waive it and have the matter bound over to the Wayne County Circuit Court.
Is there any objection to the proposed waiver?
No, Your Honor.
Thank you. Mr. Gardner, I just need to ask you a few questions. Do you understand the allegations against you, sir?
Yes.
Do you understand that you have a right to a preliminary examination?
Yes.
You understand that if an examination were to occur, that the prosecutor would need to establish by probable cause standard only crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. Do you understand that?
Yes.
And that if the prosecutor were able to meet that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes.
Now, the representation has been made that you wish to waive, to give up your right to a preliminary examination. Is that true?
Yes.
Do you understand that that would mean that this matter would automatically be bound over to the circuit court for further proceedings without the benefit of an examination at this phase?
Yes.
And is that how you wish to proceed?
Yes.
All right.
Yes.
Are you doing so rather voluntarily, sir?
Yes.
Do you find the waiver to be knowingly and voluntarily given? The matter will be bound over to the circuit court as charged. The arraignment on information date is going to be August 18th at 9 a.m. Is there anything further, Quinn?
No, Judge.
Okay, prosecution?
No.
Thank you. Okay, we're all set. Thank you so much. Oh, the examination waiver form, has that been returned?
I'm going to do that today now.
Okay, so we need that in order to process the bind over. We do need that paperwork this morning, sometime before lunchtime, so that it can be properly processed to coincide with the arraignment date.
Understood.
Okay, thank you so much.
Can I, could you spell your name?
W-E-I-S-E-R.
Mr. Buckner?
Yes.
Family.
Yeah.
Judge, we're ready to go to an exam, I believe, Mr. Simons.
Okay.
Can you bring parties on fields in?
Did you want me to put a sticky note on that about the waiting for the examination waiver form?
I'll remember.
Okay, all right.
Calling parties on fields, case number 2062604, the people of the state of Michigan versus Eric Javon Fields. The defendant is charged with count 1, Carrington Field. This matter is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Sam Weiser on behalf of the people requesting permission to practice under MCR 8.120 under the supervision of Brent Daly, P84009.
Thank you. Granted.
Good morning, Your Honor. Jonathan Simon, P35596 for Mr. Fields.
Thank you. Mr. Simon, good morning to you. Could you please state your name? Just keep your voice up.
Eric Fields.
Thank you. All right, are there any preliminary matters before we begin?
No, Your Honor.
Mr. Simon?
Sequestration.
Sequestration is granted. Is there an officer in charge you're going to ask to be in the courtroom?
Not the officer in charge, just two separate officers.
Okay, but you're not asking for anyone to be present in the courtroom
No,
right now? Okay. Sequestration is granted. The courtroom is already restricted from spectators. The only people in here are those associated with the case, working the court, and another attorney and an officer. Presumably you're on a different matter, correct, officer? Thank you. And good morning to you.
Good morning.
The Zoom gallery, I am going to restrict it. So I will be placing individuals in the waiting room with the exception of counsel on unrelated matters. Okay. I'm sorry, and the third tier to sequestration is that this is live streaming on YouTube, so if there's anyone watching that live stream that shouldn't be watching because you're either a witness or a potential witness, now is the time to stop from watching that live proceeding, as it may preclude you from testifying in the future. That being said, please call your first witness.
The people call Police Officer Fields.
Tiffany Jones.
Yes, this is Damian Daniel. I'm just on her phone.
Oh, okay, Damian Daniel, I noticed you had your hand raised. Was there a question?
Oh no, I've been asked a question and I had thought I unraised my hand. I'm sorry.
Okay, no worries. I'm gonna put you in a waiting room and we'll bring you back just a moment.
Okay, thank you.
Thank you. Okay, please state your full name,
Derek Fields,
and can you spell your first and last name, please?
DEREK, FIELTS.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You make your way over here. This gate, half gate will open up towards you, and just watch your step. Once the officer is situated, you may proceed.
Good morning, Officer Fields. Can you please restate your name for the record?
Derek Fields.
Are you currently employed at the Detroit Police Department?
Yes, ma'am.
In what capacity?
I'm a police officer,
For how long?
3 years.
Were you employed in that capacity on December 19th, 2020?
Yes, ma'am.
Did you in fact work on that date?
Yes, ma'am.
What is your partner's, or were you by yourself or with a partner, sorry?
I was with the partner,
What's your partner's name?
Emmanuel Roberson,
Were you in full or modified uniform?
modified now,
Were you in a full scout car or on foot?
semi-marked.
Did your duties as a police officer take you to the area at or near 14158 Edmore
Yes, ma'am.
in the city of Detroit,
Yes, ma'am.
Wayne County?
Yes, ma'am.
What is at that location?
A house.
And what brought
I'm sorry, ma'am.
you to that location?
Routine patrol, ma'am.
And when you went to that location, did you observe anything?
Yes, ma'am.
What did you observe?
We observed.
Objection to what we observed.
I'm
Objection
sorry, what did
sustained.
you observe?
Objection sustained, but let me just explain to him why. So even though you may have been working in tandem with a partner, please make sure you restrict your answers to the singular I as opposed to we. Thank you.
Okay.
You can go ahead.
Okay. I observed the offender walking across the street.
And did the offender,
Objection to the conclusion offender.
Objection sustained as to the characterization.
one second, Your Honor. When you observed the possible offender, what did you observe him doing?
I observed him walking, and I observed a firearm partially protruding in his left waistband.
What part of the firearm did you observe?
I observed the rear of an extended magazine.
And you know it was a rear of the magazine just from prior experience as a police officer?
Yes, ma'am.
Did you do anything after observing the gun on the offender?
My partner did, ma'am.
Did you approach the offender, possible offender?
Eventually, yes, ma'am.
And when you approached, what did you do?
When I approached
And do you see that the person that you observed in the courtroom?
yes, ma'am.
Can you point him out or her and anything that they're wearing?
Yes, ma'am. He's sitting over there with a light blue button-down shirt, ma'am.
Let the record reflect that the witness identified the defendant.
The record will so reflect identification of the defendant.
Thank you.
You're welcome.
I'm sorry, what did you say after you said that you approached?
After I approached the offender, he began to run on foot.
Okay, where did he run to?
He ran to the back of the location.
Okay, did he do anything suspicious or out of weird?
Objection, leading.
Objection sustained.
When he ran to the backyard, what, if anything, was unusual or not unusual of his behavior?
I observed him reach and remove the firearm from his waistband.
And did you see him do anything with the firearm or?
No, ma'am.
Okay. Prior to him running, did you ask if he had a CPL?
Objection, leading.
Objection sustained.
Did you, okay. One second, Your Honor. What, if anything, or any conversation prior to him running, did you have the offender?
My partner asked.
Okay, if it was your partner then. So what happened after he took off to the backyard and you chased on foot?
He surrendered.
When he surrendered, what did he do exactly?
He raised his hands in the air.
Did he say anything?
I don't recall.
And when you detained him, did you find anything on his person?
I did not find anything on his person.
Did you find anything in the vicinity of the backyard?
Yes, ma'am.
What did you find?
It was a black firearm in the bush in the rear of the location.
And were you, your partner, and the offender the only ones in the area at this time?
Yes, ma'am. Ma'am, I rephrase that.
Yes.
There was another scout in the area
Okay.
that eventually located.
Okay, still police officers though?
Yes.
Okay.
That eventually located what?
The firearm.
Okay.
Objection, the firearm, perhaps maybe a firearm, maybe more appropriate response.
Objection sustained.
And who recovered the gun from the bushes?
I did.
After the gun was recovered, what did you find when you searched his lien?
I'm sorry.
What did you find through searching his lien after recovering?
His name, ma'am?
Okay.
Wait,
I'm sorry, I didn't. Can you rephrase the question? I'm sorry.
Yeah, one second. I'm sorry. Did you run the defendant's name in the lien?
Yes, ma'am.
And after doing that, did you observe anything in the lien?
No, ma'am.
Nothing that is relevant to owning the gun?
Objection, asked and answered.
objection
Nothing.
sustained.
Your Honor, Ms. Weiner is attempting to.
You have to put your appearance on.
Bryn Bailey on behalf of the people, Your Honor.
And what were you going to indicate?
That Ms. Weiner is attempting to gain clarification as to what nothing means. So it is not in fact asked and answered.
Well, then she needs to ask it a different way.
Did the lien indicate whether or not the defendant had a CPL?
Yes, ma'am.
What did it indicate?
He did not have a CPO.
Do you know the defendant's actual address?
Not to my knowledge, ma'am.
One more second, Your Honor. All right, Your Honor, I'm done with questioning this witness.
Well, I'd like to know, you indicated that a firearm was recovered in the bush area behind the location. Where was that in relation to where you saw the individual that you identified as the defendant?
Ma'am, he was in the backyard and the bush was actually very close. He was like in the middle of the backyard and the bush was in the same vicinity as the backyard.
What does that mean though, like in terms of spatial distance?
It's a possibility that he could have threw the firearm in the bush.
Like, how close is what I'm saying? Like, we weren't there, so like, how close? I mean, can you provide an answer with regards to distance?
No, ma'am, I don't want to be off distance wise.
Was it? Okay, all right. Cross-examination?
Morning, officer.
Good morning, sir.
Officer Fields, correct?
Yes, sir.
Okay, and the gentleman you pointed to, his name is also Fields, correct?
Yes, sir.
Okay, do you know if you're related?
No, sir.
No, you don't know?
I'm sorry, sir.
I said, no, you don't know, or no, you are not, as far as you know?
No, we're not related, sir.
Now, you and your partner, Officer Roberson, were on routine patrol,
Yes, sir.
and what caused you to vote? Well, first, let me ask you, were you the operator or the passenger of that vehicle?
Passenger.
Okay. And you were cruising Edmore Street?
Yes, sir.
Okay. And you happened to focus your attention on Mr. Fields?
Yes, sir.
And what caused you to do so?
I'm standing in the street, sir.
Okay. Because he was standing in the street, you became a little bit more focused on this gentleman?
Yes, sir.
Okay. While your partner is busy operating that vehicle,
Yes, sir.
and the vehicle is still in motion,
Yes, sir.
and so as far as you know, your partner's attention is still focused on the road ahead, correct?
Yes, sir.
Okay. Now, what caused you to ask your, well, did you ask your partner to stop the vehicle?
I don't recall.
But at some point, the vehicle did stop.
Yes, sir.
Now, when you first observed Mr. Fields, approximately how far away from him would you say you and your partner were located?
I don't recall.
A house, two houses, half a block?
I don't recall.
At the time the vehicle stopped, how far away from Mr. Fields would you say you and your partner were located?
We were directly in front of the house of the driveway that he was walking towards.
Okay. So he is walking toward this house on Edmore Street,
Yes, sir.
and you and your partner stop the vehicle, when your partner stops the vehicle in front of that house.
Yes, sir.
It was at that point that you contacted Mr. Fields,
Yes, sir.
and how did you do so?
My partner, he made contact, sir.
Okay. So you were still situated in the vehicle,
Yes, sir.
and your partner parked and exited the vehicle,
Yes, sir.
and you remained in the vehicle as your partner?
No, sir.
You both exited the vehicle?
Yes, sir.
Okay. And did you both approach Mr. Fields?
Yes, sir.
And your partner said something to him?
Yes, sir.
Did you say anything to him?
I don't recall, sir.
Now, you made an observation, correct?
Yes, sir.
regarding something you believe to be on Mr. Fields' person?
Yes, sir.
And how far from Mr. Fields were you when you first made that observation?
Sir, that's when we parked the vehicle.
Okay. And how far from Mr. Fields would you say you were at that time?
I don't recall the exact distance, sir.
Something that you believe to be the magazine of a firearm?
Yes, sir.
Okay, you didn't see any firearm, did you?
Saw the magazine, sir.
You saw a magazine, what you believe to be a magazine, correct?
Yes, sir.
And Mr. Fields proceeded into the backyard of that location,
Yes, sir.
and then he was detained by yourself and your partner,
Yes, sir.
and there was no magazine on his person, was there?
No, sir.
Now, at some point, other officers in the area also attended to this location?
Yes, sir.
Now, while Mr. Fields was detained, who was detaining him? Who was standing guard over him?
I don't recall, sir.
Was it you? Well, would you know whether, strike that, if you don't know, you don't know. Suffice it to say, he was disabled, correct? From any further movement, correct?
Yes, sir.
And while that detention was taking place, efforts were made to search the area?
Excuse me, you said? Oh, okay.
Yes, sir.
Okay. And, but you don't recall who was conducting the search?
Of the area, sir?
Yes.
Yes, sir.
Who was that?
P.O. Fagoso, sir.
Sorry?
Officer Fagoso, sir.
Okay. He was one of the officers who reached in the neighborhood who responded to your request for backup?
Yes, sir.
Okay. How many other officers responded, did you know?
I don't recall, sir.
And you don't recall who was standing over Mr. Fields, and you don't recall who was searching the area for this so-called weapon, correct?
I do, sir.
You do what?
I recall who was searching the area, sir.
Okay, who was searching?
Officer Fagoso, sir.
Okay, well, where was your partner?
I don't recall, sir.
At some point, something was found,
Yes, sir.
and how long did how much time transpired between the time Mr. Fields was initially detained and something was found?
I don't recall, sir.
Would you say it was about a half an hour or more?
I don't recall, sir.
Now, how big would you say this backyard is?
Maybe average size, sir.
In terms of dimensions?
I'm not sure, sir.
All right, well, I don't know what an average size yard is. Can you describe the length or the width?
I can't, sir.
Now, at some point you say, was it Officer Fagoso found something?
Yes, sir.
And that something was a firearm?
Yes, sir.
And that firearm was found, what, did you see Officer Fagoso recover that firearm?
No, sir.
Who did, what did you see?
I recovered the firearm,
Okay.
sir.
And where did you recover this firearm?
From the bush
Okay. And where was this bush?
in the backyard of that location, sir.
And, you placed that firearm on evidence?
Yes, sir.
Wait, say again? Ask that question again, please.
You placed that firearm on evidence?
Yes, sir.
Okay. Now, do you know, you didn't see Mr. Fields place that firearm in that bush, did you?
No, sir.
And you don't know how long that firearm has been in that bush, did you?
No, sir.
And did you know whether the firearm was submitted to, for any forensic evaluation? For For example, fingerprints, DNA, anything of that sort?
I'm not sure, sir.
Do you know if Mr. Fields was tested for gunshot residue or to determine whether he had recently handled a firearm?
No, sir.
Was there an evidence tag number associated with that?
Yes, Your Honor.
What is it?
I'll have to review my report.
Would that refresh your recollection?
Yes.
Okay, is there any assistance prosecution can give in that regard?
I'm sorry, Your Honor.
Oh, he was trying to answer my question about the evidence tag number, but he doesn't know it by heart.
Yes, Your Honor. I can either provide this officer with his report that contains the evidence tag number.
That's what he's asking for.
Permission to approach?
Yes.
Your Honor.
Judge, the officer appears to be reading it.
And for an evidence tag number, he is permitted to read the number unless it's like 3 numbers. Thank you.
Very well.
Your Honor, the evidence tag number is 646805.
Thank you.
I have no further questions.
Thank you. Any redirect?
Yes, Your Honor. So when the defendant pulled the gun from his waistband.
Objection. They're assuming facts, not in evidence.
Your Honor, I believe.
Hold on. Is it?
I don't think so.
Well, it was testified out of this officer's mouth. Well, okay, perhaps the characterization of pulling. This officer used the word removed from waistband.
I will adjust pulling to removed, Your Honor.
Thank you.
When the defendant removed the gun from his waistband, what, if anything, did he do with it?
Can you rephrase it, ma'am?
So when he removed it from his waistband, did he hold his arm out
Judge,
straight? Did he raise it over his head?
This is beyond the scope of my cross-examination.
I don't believe it is, Your Honor.
How so?
The, Mr. Defense Counsel asked this officer if he saw what the offender did with the, I believe he used the term magazine, but if he asked him if he saw him put it into the bush, and I think that opens the door for what he did actually observe.
Objection overruled.
So after it was removed from the waistband, did you observe the defendant put his arm out straight, raise it above his head, or something else?
Objection, legal.
Objection sustained.
Your Honor,
I think you can ask that without suggesting even multiple answers. You can.
okay. What, if anything, did you observe the defendant do after he removed the gun from his waistband?
All right, please recollect my memory.
Would reviewing your report refresh your recollection?
Yes, ma'am.
Okay, please do so. Okay, so after you observed the defendant removing the gun from his waistband, what, if anything, did you see?
Ma'am, he had the firearm in his hand, but I did not see any further movements.
And when you caught up with the defendant, was the gun still in his hand?
No, ma'am.
Objection, suspected, I think.
Your Honor, this officer has testified that he's an officer. He carries a gun every day. He saw the magazine. He saw the gun completely out of the waistband.
not a suspected gun at this point. He's testified as to what he saw.
Objection overruled.
Did the defendant have the gun on him when you caught up with him?
No, ma'am.
Now, the gun that was recovered from the bush, did it have an extended magazine?
Yes.
Did that extended magazine appear to be same or similar to the one that you observed on the defendant?
Yes.
Well, similar I'm okay with, the same I object to.
Okay, did it appear to be similar, Officer Fields?
Yes, Your Honor.
Thank you.
Well, Your Honor, then I'd follow up with, was it the same magazine that you saw?
Objection.
The objection sustained.
Your
You're
Honor,
asking this officer if what was recovered was indeed the same?
yes, Your Honor, he observed the extended magazine.
Objection sustained.
Okay.
He testified very succinctly and directly that it appears to be similar to what he observed.
Yes, Your Honor, no further questions from this witness.
Nothing further.
Okay, thank you, Officer Fields. You may exit the courtroom.
Actually, never mind.
Yes. One moment.
Nothing further.
Thank you, Officer Fields.
Thank you, Your Honor.
Any further witnesses for the prosecution?
Your Honor, if we can have 2 minutes, that would be appreciated.
Okay.
Thank you.
What is set up? Oh, Ms. Cataray, and Mr. Blue, oh, I don't see Mr. Bloomers though. We were waiting to recall a matter, but Mr. Bloomers must be walking over. Ms. Dunn?
Yes, ma'am.
Good morning to you. I guess we're waiting on, we may have your person, hold on. No, I think that's Ms. Cataray's client, sorry. Give us just a moment, we're waiting on Mr. Bloomers, presumably he's making his way into the courtroom. And here he is.
I thought I had Mr. Slusky.
Oh, okay, thank you, Ms. Dunn. Ms. Cataray, are you there?
Yes, I am.
Okay, Mr. Bloomers, can we recall this matter?
Yep.
Oh, were you going to present another witness? Yes. Okay. We're going to just try and handle one matter quickly so Ms. Cataray can get moving. This is a recall of People versus Najan Boyer, 21059588101. Can I have appearances again, please?
Jacob Bloomers on behalf of People.
Danielle Cataray, P77162 on behalf of Najan Boyer.
Thank you. And Mr. Boyer, please state your name, sir.
Good morning, Najan Boyer.
Morning. Okay, so we had paused on this matter so that we could, so that Madam Defense and the prosecution can lay eyes on at the very least, the investigator's report. And I do recall that Mr. Bloomers had indicated that since Monday, he has had contact with the complaining witness in this matter, and she has indicated her concerns regarding a reduction or an amendment to the bond. Ms. Cataray, did you receive that report?
I did receive the report. I just want to object to the prosecutor entering in a statement from the complainant. Also, I believe he said that she didn't feel safe if the defendant was out on personal bond, which I don't know what that means. But if statements like that are going to be made, then I'd like to be able to question her about that. I don't know if she feels safer if he paid for her bond or what that's meaning to say, nor do I know if she's saying that with some sort of nefarious intent to just keep Mr. Boyer in jail. So that's my objection for the record. But I'd like to withdraw the bond argument anyways and just set this for preliminary exam.
Okay, so today is the 28th.
Well, Judge, while
Yes.
we're on the subject of bond,
Yeah.
I was looking at the ROA. I didn't see a GPS tether condition on there. And so unless the court has different information, I would move to modify the bond to add that GPS tether condition referring.
There is, according to my pretrial release order, no GPS tether that was ordered. Now, in a case like this, where the allegations include domestic violence, that's usually something that's done as a matter of course. I've had an opportunity while we've had this lull to review what both prosecution and the defense have before them. I am concerned that there was not a GPS tether that was imposed as a condition in the event that the defendant does make bond, but I was waiting to see whether or not the prosecutor was going to remark on that, and he has. I am going to add the condition of the GPS tether, not because of any statement that the complaining witness purportedly said to the prosecutor, but because a $15,000 10% bond with only the restriction that he makes sure that he has no contact. In this sort of nature of an offense, I do not believe is sufficient. That GPS tether should have been imposed in order to protect that second prong of the bond analysis, which is the safety of the community at large, in particular, the complaining witness. When there's a domestic allegation, there's usually a heightened temptation to reach out. And while this case is pending, I certainly want to do everything possible to ensure that there's no violation of the no contact, given what's before the court. So I am going to, Madam Clerk, could I trouble you for a bond amendment form or bond, the title of it, I guess, is bond reduction. And Madam Defense, if you'd like to set this, we can set this as early as 7 days from now. As long as, 7 days gives Mr. Prosecutor an opportunity to notice the complaining witness. So would you like it on the 4th of August?
I think the most important thing right now is that I don't have discovery, and that I also want to object. I think it's inappropriate that the prosecutor is making bond argument without providing me any discovery and without putting it in writing. I should at least have an opportunity to have the discovery and review it before he asked for a tether. I mean, it just seems arbitrary. So that's my objection.
Yeah. And I appreciate it. Your objection is duly noted, but the court does have discretion to make its own amendments, not to my previous bond, but to a bond that was made by a magistrate, that the court finds there's been an abuse of discretion. So let me be clear. I do find that there has been an abuse of discretion by the arraigning magistrate to not impose a GPS tether. And while this case is pending, in the event that the defendant does post bond, it would be derelict of me to sit here and not do what I think is appropriate. So I am going to impose that additional requirement that a GPS tether be imposed. Your objection is, however, duly noted. But a GPS tether is going to be imposed with the restrictions continuing that there be no contact, not directly or even indirectly. So even while you're in custody now, there's to be no contact. If she happens to call you, you can't engage with her. If you post bond and you get out, then even if she comes to your doorstep, that does not then give you permission to engage with her. The bond is on you. It is important that you abide by that bond condition to safeguard your bond. That would include letters, telephone, texting, any form of social media outreach to the complaining witness. Do you understand that, sir?
Yes, ma'am, I understand.
Thank you. Again, if you would like your exam on August 4th, 5th, 6th, any date I would say starting on the 4th, gives us 7 days. So the 4th, 5th, 6th, we don't have any space for it, but with the fact that your client is in custody, we're gonna make a way.
So I am in your courtroom on the 4th and 6th for.
Which, like?
I think that the 5th, if you have that.
Okay. Now, Mr. Bloomers, Madam Defense has already expressed her concern regarding the lack of discovery. So I'm going to ask, and I know that you are generally on top of the discovery for what you can control. Sounds like there's some things going on that's outside of your control. So I would ask that you attempt to reach out to whomever that entity is that can make it happen so that Ms. Cataray can get that discovery as soon as possible, as opposed to next week or on the date of the exam, okay?
Absolutely, Judge. And I'll just say for the record, I do have 4 video files in my possession, which I will get to Ms. Cataray by the end of the day today. And then I will do everything I can. I will get that paper by the end of this week, one way or another.
Okay, that sounds good. The exam will be set for August 5th. At 11 a.m.
I just have another thing, the 911 call also.
All right, I will order those today as well.
Okay, anything further?
No, thank you.
Okay, Mr. Bloomers,
Speak
anything
to my
further?
attorney, please.
Nothing from the.
Oh, yes, did you want a breakout room again?
Yes, ma'am.
Are we ready to resume back with this? This is a recall of People versus Fields. Eric Fields, 2006264. Can I have appearances again, please?
Sam Weiser, on behalf of the people requesting permission to practice under MCR 8.120 under the supervision of Bryn Bailey, P84009.
Granted.
Jonathan Simon, P35596 for Mr. Fields.
Thank you. And Mr. Fields, your name again?
Eric Fields.
Thank you. Your next witness?
Judge, I object to any further witnesses. The people have took the opportunity to go out in the hall, prep the witness based upon the testimony, I suspect, of the first officer in violation of the sequestration rule.
Is that what's happened?
Your Honor, no, the people did not speak with Officer Robertson about anything that Officer Fields testified to.
Please call your next witness. Your objection's noted, but the prosecution has responded. As officer of the court, I take her at her word. And for the record, that was Bryn Bailey speaking.
Yes, sir. The people called Police Officer Robertson.
Who are you calling for?
Sir, could you please state your full name and spell your first and last name, please?
Full name Emmanuel Robertson. First name EMANUELROBERSON.
Thank you. Could you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. If you have your way over here, this half gate will open towards you. Once he's settled, please proceed.
Good Morning, officer. Can you please restate your name for the record?
Emmanuel Robertson.
Are you currently employed at the Detroit Police Department?
Yes,
In what capacity?
as a police officer.
And for how long?
I'm going on 5 years.
Were you employed in that capacity on December 19th, 2020?
Yes,
Do you in fact work on that date?
yes,
Were you by yourself or with a partner?
with the partner,
What is your partner's name?
Officer David Fields,
Were you in full or modified uniform?
modified,
On foot or in a scout car?
scout car,
Was the scout car fully marked or something else?
semi-marked.
Did your duties as a police officer take you to the area at or near 14158 Edmore?
Yes,
Is that in Detroit,
yes,
in Wayne County?
yes.
What is at that location?
This is a neighborhood block.
When you arrived at that location, did you observe anything?
Yes,
What did you observe?
I observed the offender.
Objection,
Objection is,
characterization.
objection sustained.
Okay, I observed the offender.
Hold on, so it was sustained because you used the word offender.
Okay,
So if you could use another word as opposed to the
okay.
word offender.
All right, Mr. Fields, I observed him standing in the street on Edmore.
And do you see Mr. Fields in this courtroom?
Yes, he's to my left with a collar shirt on.
Let the record reflect that the witness has identified the defendant.
The record will reflect of the defendant.
So you said you observed him,
Yes, he was standing in the street.
and did you observe anything else?
I was driving down Edmore, and he walked from standing next to a van that was parked on the north side of Edmore. And I observed a firearm on the offender.
And you know it was a firearm from,
Yes, I observed a textured grip of a black firearm and an extended magazine on the offender's hip. And he was walking,
Wait a minute, could you repeat that again, please? I'm sorry.
a textured grip of a firearm and an extended magazine protruding from inside of the offender's waistband, Mr. Fields' waistband. And he was walking to that address you brought out earlier, like 14, I don't recall the rest of the address. And as we continued driving towards offender's direction, he looked in our direction and started walking faster. And then I pulled alongside and asked him if he had a concealed pistol license.
did you notice the defendant do anything as he ran,
Okay, so,
Objection, you said it walks faster.
or as he walked back?
yes, so he walked fast towards that address, and then I asked him if he had a concealed pistol license. He shook his head no, and he said no. And then when we exited the vehicle to further investigate, he took out running on foot as we walked towards him.
And when he ran, did Mr. Fields do anything?
When he ran to the backyard of that location. And I saw him reaching in his left waistband area. And then soon after, we was right behind him and then ended up in the backyard together with him where he surrendered.
Do you know if any weapon was ever recovered?
Yes, so when he surrendered, the firearm was no longer on his waistband.
Objection, assumes facts, I mean, suspected firearm.
It was a firearm.
If you could, to indulge the court, if you could just add the language in your question of suspected firearm.
Okay, sorry.
Okay, I'm sorry.
Could you ask the question again?
Okay, sorry. Did you see your partner or anyone else recover the suspected weapon?
Yes, so he surrendered in the backyard. The firearm was no longer on his hip. And so we,
See, Judge, that was my objection, not the question, but the answer. At that point, there's no evidence that it is in fact a firearm other than suspicion.
And that's noted. Thank you.
Your Honor,
Please proceed with your next question. Your concern regarding the language that the officer is using is noted, and you will have an opportunity to cross-examine. Please
Thank you.
proceed with the next question.
When Mr. Fields was detained, about how far away from the suspected weapon was he?
So he was detained in handcuffs. He was approximately 6 feet away from the bush where the firearm was recovered. And the firearm recovered was the make and model of the firearm that I observed on the hood.
Yeah, I guess, Sims facts, not in evidence.
Objection sustained.
1 second, Your Honor. The suspected weapon seems to be the same, or the same weapon as you observed on the, Mr. Fields.
Yes, the firearm.
Can you repeat the question, please?
I said, did the suspected weapon seem to be of the same make and model?
The firearm was the same make and model but one I carry every day off duty, and for two, that's what I saw on the offender's hip. It was the same make, model, same extended magazine, same texture grip that I saw when he was walking towards the house.
And were any rounds found in that chamber?
Judge.
You'll have an opportunity to cross. Thank you.
Yes, the firearm was loaded with several live rounds, and it had 1 round chamber.
Your Honor, objection, that's not an element of defense, it's irrelevant.
I didn't hear you. That's what?
The testimony regarding what may have been contained in the weapon is irrelevant.
Thank you. Objection overruled. Objection was overruled.
Thank you, Your Honor. This might seem like a weird question, but do you remember the weather from that day?
It snowed earlier in the day.
And when your partner recovered the gun, and did you see him recover the gun?
Yes, when it was recovered, the firearm was not wet. It didn't have snow on it, and it seemed fresh as if it was just placed in the bush.
Okay, thank you. Do you know the actual address of the defendant?
Wait, say that. What was the question?
Do you know the defendant's address? His actual address?
I'm sorry, what was the objection?
Objection, hearsay.
Well, I don't.
Well, I mean, I guess it's a yes or no question, but the follow-up would be hearsay.
The objection is overruled. Do you know the address of the defendant, Mr. Fields?
I can't recall. I have to refresh a report.
No further questions.
Thank you. Cross-examination.
Thank you, Judge. Officer Robert Robertson?
Yes.
Good morning. You say you were in a semi-marked vehicle?
Yes.
Can you describe what distinguishes a semi-marked vehicle from a fully marked vehicle?
Our fully marked cars are white and blue. The semi-marked is a black vehicle that says Detroit Police on both sides.
Okay. And does it have lights? Does it have sirens?
It has lights, sirens. Yes.
So, from all outward appearances, it is no police vehicle, as it is marked, although perhaps less so.
Yes, it's marked.
Okay. And you also indicated you were in a modified uniform. Can you describe what that would be?
It would be
Is that what you're wearing today?
partially. You would have to include a vest, and then you would have to include a duty belt. You know, I'm not in full uniform right now.
Okay.
But it's these colors, black shirt with
So
solid.
you're wearing a black polo shirt?
Yes, with green
and
pants.
green carpenter pants, or, I mean?
Yes.
Okay, thank you. But with, at that time, you also had a vest and a badge?
Yes.
The badge was what, on a chain around your neck?
It was on my belt.
Okay, thank you. Now, you saw what you believed to be a weapon when you were operating the vehicle as you were proceeding down Edmore, correct?
No, not correct.
How was that wrong?
I saw a firearm.
Well, at that point, well, you saw something that appeared to be a firearm, correct?
I don't know if that's the proper wording. I mean, I saw a firearm.
You know, this is just going to be argumentative. I think the court's aware of the issue, and I answer the question.
Thank you. Any redirect?
No, Your Honor.
Okay, thank you, officer. You may exit the courtroom. Okay, are there any further witnesses for the prosecution?
No, Your Honor.
No witnesses for the.
Is there a motion?
Yes, the people move for a buy over on count one. Your Honor, we heard that the defendant was at the location. Officers testified that they witnessed the defendant walking down the road and then changed his direction and pace as he saw the officers. The officers also noticed what could have been a suspected firearm on this person. When they approached the defendant, they asked if he had a CPL. He says no and then runs. When he runs, both officers testified to the fact that they saw him move his left arm in a drastic manner. And then as he ran, he fled to a backyard where he was later detained. The gun was later recovered about 6 feet from the defendant's location in a bush. It had previously snowed that day. The gun was not rusted, was not wet. It appeared as if the gun had just been placed there, according to police officer Roberson's testimony. One second, Your Honor. Officer Roberson also said that he had testified that there were rounds found in the chamber that matched the type of gun that was also recovered, and that he also knows from previous experience and personal experience that it's around for a Glock. For these reasons, the people have met the burden of probable cause to testify over.
Response?
Question of fact.
It is a question of fact. Prosecution has met the burden that is required at this phase, which is probable cause. Probable cause that a crime was committed, probable cause that you were the one that committed that crime. With the testimony of the two officers that was presented, the court has determined that there is indeed a question of fact that is relevant here. So the matter is going to be bound over as charged with an AOI date of August 18th. Anything further?
No, thank you, Your Honor. The court said August 18th.
August 18th at 9 a.m.
Very good. Thank you, Judge.
Thank you, sir.
have him here for the exam.
Okay, well, I'm gonna grant that. I do find good cause. I'm gonna grant the request for an adjournment of this examination. The only thing is that we cannot turn this around anytime soon, so you'll probably need to flip several pages in that calendar of yours. We probably won't be able to accommodate until October or November on a reschedule for non-custody.
That's fine, Your Honor.
Just October 18th at 11 a.m.
That's fine with me.
October 18th, 11 a.m. it is.
Thank you very much, Your Honor.
Thank you, Judge. Yes.
Ms. Shabazz, what case are you on?
Is Mr. Mitchell still in the waiting room?
Mr. Humphreys, I don't want to hold you up, but I have a hearing in Macomb Circuit at 10:30, so I have to go and I'll come back. I don't know.
Oh.
I have the co-defendant on your case. I shouldn't be too long.
Oh, okay.
Well,
We
we don't have him video anyway. Your client's not up on video yet.
Well, my client, Tammy?
Right. I don't believe he's been up on video yet.
He's in jail. I know that. He's in Division 1.
I know that, but the jail hasn't made him available to us yet.
Gotcha. Okay, I'll be back shortly then.
Okay.
Okay. All right, I'll just be patient.
I understand.
Yeah, I got you. I'll see if I can find him.
And unless the court wants to give us a date, and then when they come on, then give them the same date.
Let's try and wait just a moment. Division 1, what's your name?
It's Tipton, and I don't see Miss Kraft signed on yet. I sent her an email. Oh, Miss Silver was signing in and out. Judge.
David Tipton.
I'm sure.
Thank you.
I'm sure that's what she's doing. I'll send her an email, but I don't know what we're getting ready to start again. Is anyone else signed on that needs to check in?
Yes, can I please check in? This is Attorney Davenport.
What case are you on?
Anaya
Lipscomb?
Lipscomb? Yes, ma'am.
Okay, and what did you want to do this morning?
We were scheduled to, I was going to step away from the case last week, and then we rescheduled it for this week. I think there was an exam going on.
All right, is Mr. Lipscomb signed on? He was signed on earlier.
Yes, I'm here.
I'm gonna. I don't know what's. Calling parties on Lipscomb. Case number 1859583, the people of the state of Michigan versus Anaya Marche Zakarla Lipscomb. The defendant is charged with Count 1, larceny in a building. Count 2, embezzlement, agent or trustee less than $200. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Morning, Your Honor. Curtis Davenport, P82678, on behalf of Ms. Anaya Lipscomb, who is present via Zoom today.
Okay, so could I trouble you to please state your name?
Anaya Lipscomb.
Thank you, and good morning to everyone. We're here today for a PCC. What's your pleasure, counsel?
Your Honor, at this time, I unfortunately have to withdraw my representation, stepping away from a lot of my cases. So this is one of them. We got some personal stuff going going on at home. So I have to stick with it.
Audio is breaking up just a little bit, but I think I heard the gist of it. Madam Court Reporter, did you need him to repeat anything? Could you please repeat what you said? Your audio dipped in and out.
I'm sorry. At this time, I need to withdraw from this case. I've got a lot of stuff going on personally, and I'm withdrawing from a decent amount of cases.
Okay, I certainly understand. Ms. Lipscomb, have you independently talked to counsel and understand what's going on here?
Yes.
Okay, so what we're going to do is, Madam Clerk is on the phone right now, attempting to secure a new court-appointed attorney. If you could be patient with us, Ms. Lipscomb, and wait just a few more minutes, whomever that new attorney is going to zoom in just a moment. Then I'll put you in a breakout room so the two of you can speak, okay?
Okay, thank you.
You're welcome. Mr. Shabazz, you are withdrawn from this matter, and I wish you well. I couldn't hear you, but have a great day. Thank you.
Judge, Mr. Stalin had his case scheduled at 9:30, and then we have this in custody case.
Okay,
So what to do?
If we have the in custody case that's right here before us ready, let's start it.
Was, Mr. Stalin, was your case going to be a hold?
Yes, Your Honor.
Oh, and is it non-custody?
It is.
That is correct.
Thank you. Let's call you do understand, right? I mean, I can give a fuller explanation, but.
No, I don't need a long explanation.
Wait, I'm sorry. I just
want
to say that for in custody matters, I don't have discretion. That's the directive from the court, that those matters be handled first. Please bring him out and let's call the case.
Is this a hold, Your Honor?
Oh, I don't know. Is it?
I'll call you with some shit about it.
Calling parties on Hilton. Case number 2155812. The people of the state of Michigan versus Michael Hilton. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle, habitual offender, fourth offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
And good morning, Neighborhood Defender Service by Lauren Anderson, P85191, on behalf of Michael Hilton, who is present.
Thank you. Mr. Hilton, please state your name.
Michael Hilton.
Thank you. What are we doing here today?
Your Honor, at this time, the people move to dismiss this case against Mr. Hilton. This incident arose out of another incident that happened in Tuscola County. Mr. Hilton is being charged for that in Tuscola County. And given the duplicative nature of this prosecution, it doesn't make a whole lot of sense to proceed on both cases. The witnesses are up there. This would be a lesser included offense, essentially. And so the people move to dismiss.
Any objection?
No, ma'am.
Okay, I am preparing an order of dismissal right now. Mr. Slusky, I will need your signature on this as the moving party. And if you could please, I've checked the box titled other. If you could add in whatever language you would like. I don't want that to be blank. And return that back to Madam Clerk, and then we'll give copies to both prosecution and defense. The matter is now dismissed without prejudice. Do you understand, sir?
Yes, ma'am.
Okay.
Ms. Hilton, what's your P number again?
85191.
I can't enter that in here. It won't take it.
We've been dealing with this.
Okay.
It's not in the system.
I got you.
Yeah. And Judge, if I may, I'm sure it'll happen as a matter of course. He's here on a writ right now, but he is a type 1 diabetic and hasn't received insulin since Friday night. If there was a way we could flag that for the sheriff until he gets back up to Tuscola County.
We can put a note on the file marked medical. We can mark the file medical.
Thank you very much.
Thank you.
I appreciate it.
And what's your first name?
Lauren, Lauren.
I'll just make a note in the system with your P number.
Judge King had to call up there the other day to make sure it was real.
Here on English law, right?
Yes. Thank you. Thanks, Judge.
You're welcome.
She doesn't need to sign it.
Oh, she doesn't?
She doesn't need to sign it. Can you have Mr. Stalin come back in?
Yes.
Madam Clerk,
have we heard from Mr. Winters?
No, and I have not had time to call him in the midst of all this. But I do know, I believe his mother has.
Who was that?
Mr. Winters.
Oh,
I saw a Facebook.
First name Kevin, K-E-V-I-N, last name Jordan, J-O-R-D-A-N.
thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. You can make your way over here to this half gate and have a seat. Watch your step as you come up. Madam Prosecutor, your witness.
Thank you, Your Honor. Could you please restate your name?
Kevin Jordan.
Mr. Jordan, do you remember March 25th, 2021?
Yes.
On that date, did you go to 19227 Buffalo?
Yes.
Is that location here in the city of Detroit?
Yes, it is.
Is that in Wayne County?
Yes.
Did you go there alone or with someone else?
I went with someone else.
Who did you,
Miss, Yolanda, I forget her last name.
would that be Yolanda Lockhart?
You like her, right?
Do you recall what time you went to that location?
Not really, I know it was dark. It's probably about 9, 10 o'clock at night.
Okay. Why did you go there?
She told me to ride with her to serve somebody a paper for she was evicting them.
Okay. And when you arrived at the location, what, if anything, did you do?
I went and knocked on the door.
And what, if anything, happened after you knocked on the door?
Well, a young man answered it. He was like, well, I said, when he answered it, I seen he had a gun and things. But I said, I had his paper for him. He's like, I don't
Wait,
want
say
it.
again?
He said, I said, I have this paper to serve you. And he said he didn't want it.
Okay, so I'm gonna stop you and ask you a question about the gun. Now, when you saw the gun, was it, where was it?
Yeah, on the side. He was holding it on the side.
Was it in a holster or something
No, it
else?
wasn't in the holster. It looked like he transferred it from one hand to the other.
Objection, speculation.
Okay, so we don't want you to guess at anything.
No,
Sometimes
he-
people use the words, I think, I believe, I think. So it's really important, any answer that you give, you're giving from a point of origin that you know.
Okay.
That we don't want you to guess on any answers. That objection is sustained. Thank you.
Which hand was, this person holding the gun in?
He had it on his right hand side. He had both hands on it. And then he put it to the other side. It's like, I couldn't tell you. I just know that he had it.
So did you see him move the gun from his right side to his left side?
And yeah, it seemed like he was kind of fumbled at first, you know.
So what, if anything, happened next?
So I turned around and I told her Miss Lockhart was in her car. She got out. I said, he don't want this paper, you know.
Okay,
And I told her, I said, he got a gun in his hand.
okay. And after you turned around, what, if anything, happened next?
I started walking towards her car. He came outside, you know, behind me. But he wasn't like-
Meaning,
he just came outside. He started walking the same direction I was walking.
okay. Do you see the person that you interacted with on March 25th, 2021 here in the courtroom?
Yes, he's young man in the back.
Could you tell me what color his shirt
He's
is?
on a black t-shirt with VL.
Your Honor, may the record reflect identification of the defendant?
The record will reflect identification of the defendant.
So what, if anything, happened after you started walking back to Miss Lockhart's car?
Miss Lockhart said, put it on his car.
Okay,
The defendant was like, don't put that on my car.
okay.
So,
So a conversation ensued between yourself, Miss Lockhart, and Mr. Menafield?
so he was talking to her.
Okay. What did you do next?
I continued because I did not put it on the car. I was on this side, he was on the other side of the car. I continued to walk towards her car.
So I'm gonna stop you and ask a quick question. So while they were having this conversation, where were you standing?
I had got to the other side of the car,
Which car?
his car,
Okay. And where was his car?
parked in the driveway right off the street.
And were you on the driver's side or the passenger side?
I was on the driver's side.
Where was Mr. Menafield?
He was near the passenger side.
And where was Miss Lockhart?
She was in the street by her car.
Was she on the driver's side or the passenger side of her car?
She was on the driver's side.
So could you see her entire body from where you were standing?
No, I couldn't.
So between yourself and Miss Lockhart, her car was parked.
Right.
Okay. So what, if anything, happened next?
She told me to.
Objection, hearsay.
Objection sustained.
Without telling me what anyone said, tell me what you did.
I looked at her and I said, I'm finna get in the car. She was like, drop it on the ground. I didn't even want to drop it on the ground. He said he didn't want it.
Okay. So at this point, you made it back to Miss Lockhart's car.
Right.
And when you made it back to Miss Lockhart's car, what did you do?
I got ready to get in the car.
Did you get into the car?
Yes, I did.
And when you got into the car, what, if anything, was the defendant doing?
He was standing still on it. He was back like at the end of his car now. He was talking to Miss Lockhart.
Could you still see the gun?
At this time, I was at the car, getting in the car, and now I had my back turned this time.
Okay. So after you entered the car, did you ever see the gun again?
No, I didn't, because I didn't. I sat in the car.
Was the gun ever pointed at you?
Objection, leading.
Objection sustained.
What, if anything, did Mr. Menafield do with the gun?
Just was holding it.
Just holding
When
it up?
I left him at the time, I left him, he was holding it. 'Cause
At
I
his
told him when I
side?
got to the car, I got in the car.
Did you believe that Mr. Menafield could have injured you?
Objection, Your Honor.
What's the objection?
Form of question calls for speculation.
Objection sustained.
Well, Your Honor, if I could respond.
Well, why don't you ask the full question first? And without answering it, sir. Please don't answer the question yet. She's just asking so we can see whether or not it's an appropriate question.
Okay.
Do you believe that Mr. Menafield could have injured you?
And please, again, do not answer.
Again, Your Honor, speculation.
Objection sustained.
Your Honor.
It calls for speculation.
But Your Honor, it calls for his opinion of what's going on. Not what was going on in the defendant's mind or what the defendant was going to do or did do. What he believed could have happened. That's not speculation.
You can ask perhaps a different question to elicit the response that you're seeking.
Mr. Jordan, what, if anything, were you thinking during this interaction?
My opinion, I was thinking, as long as I remove myself in this situation, that's why I went to the car, that everything was all right.
So,
Can you lift your mask up, sir? Thank you.
what do you mean by that?
It's been asked and answered, Your Honor.
You can ask what he means by that.
When I was on the porch and I was trying to give him that paper and he had the gun and he told me he didn't want it, I felt that maybe I could have been in danger then. But once I removed myself in that situation, he didn't chase me or anything. I went to the car and I was out of the situation.
Okay. Now, as you were walking away from the house, did Mr. Menafield follow you?
He just came to the car,
So,
his car.
so,
He came off the porch, he was behind me. And I came to the other side of his car because he was on the driver's side. He was on the passenger side, I was on the driver's side.
But seeing the gun in his hand left you feeling,
Objection, Your Honor, suggesting an answer.
Yes, leave.
Your Honor,
Objection.
if I could just finish my question,
Well,
it's not
the question-
suggesting any sort of an answer.
Okay, well, again, sir, could you please not answer, even though she's looking at you and it looks like she's waiting for you to
Yeah, okay.
respond, don't answer the question.
Okay.
Seeing the gun in Mr. Menifield's hand left you feeling what?
The objection is overruled.
When I was on the porch, I felt threatened. But once I left that situation and went to the car, didn't feel threatened anymore.
And was it when you got into the car that you stopped feeling threatened or at some other point?
Once I got into the car,
Were any shots ever fired?
no.
I have no further questions.
Cross-examination.
Thank you very much, Your Honor. Good morning, sir.
Good morning.
Your relationship with Ms. Lockhart, as I understand, you are her handyman, is that correct?
Yeah, he worked for us sometimes.
Okay, and it was you also have a relationship with your son, is that my understanding? Is that correct?
Yes.
Okay, and can you state what that relationship is, please?
Objection, Your Honor. Relevance?
What is the relevance, counsel?
Bias, Your Honor?
What his relationship with the woman's
His
son?
His son's relationship with Ms. Lockhart could go to a motive and bias in this particular case, Your Honor.
I'll allow it for that limited question, but we're not gonna go down a slippery slope.
No, I don't intend to, Your Honor.
Please answer the question, sir.
At one time, her sister and my son were boyfriend and girlfriend, but they broke up and moved out.
Real quickly. Did you need that answer
You
repeated?
said, but they broke up, then he said something else.
Their relationship ended and he moved out. They
Thank you.
stayed together. He moved out.
Thank you, Mr. Jordan. Now, Mr. Jordan, my understanding is from your testimony and you made a statement, isn't that correct, to the police?
Yeah.
A written statement, and that was the following day, isn't that correct, sir?
The same night.
Okay, and you were going over to Mr. Menifield's property at the request of Ms. Lockhart, is that correct?
Yes.
And she indicated she wanted to give him some kind of landlord-tenant eviction papers, is that correct?
Yeah.
And you had those in your hand, is that correct? You have to answer yes or no.
Yes, I did, yes.
Okay, did you look at those papers to see if in fact there were actually court papers with a court case on them?
No.
Do you happen to recall what was the paper that you had in your hand? What was it?
Relevance, Your Honor?
Objection sustained. Objection sustained as to what the documents were. He already indicated he didn't look at it.
You had never read the paper at all?
No.
That you had, okay. Now, you went to Mr. Menifield's premises. It was your understanding it was his premises, his house, correct? He was a resident at the house,
Yes.
correct? Okay, and you were going there at the request of Ms. Lockhart, correct?
Yes.
And you didn't go, this was not in the daytime, correct?
Correct.
In fact, you indicated it was dark, is that correct?
Yes, it was.
It was about 10, 11 o'clock at night, is that correct?
Something like that, yeah.
And correct me if I'm wrong, at no time did Mr. Menifield ever point a gun that you claimed that you saw at you, is that correct?
No, it didn't.
So that is correct, it was never pointed at you, is that correct?
That's correct.
And correct me if I'm wrong, at no time did you ever see Mr. Menifield ever point the gun at Ms. Lockhart, isn't that correct?
Correct.
And at no time did Mr. Menifield ever chase you off his property, isn't that correct?
Correct.
In fact, at all time he was walking and said he just didn't want these papers that you had, correct?
Yes.
He indicated that this was his property and you needed,
Objection, Your Honor. Hearsay.
it's not hearsay, it's the defendant's statements as part of the corpus delicti as to what went on, Your Honor.
Well, Your Honor, it's still hearsay, even if it is the defendant's statements. There's no exception or exclusion that would allow Mr. Sallin to ask about them.
Your response?
I believe it's part of the corpus delicti, what occurred while he, during this event, Your Honor.
Objection, overruled, I'm gonna allow it.
What was the question?
Mr. Menifeld indicated to you that he did not want any type of eviction papers, isn't that correct?
Yes.
Okay. And you also indicated he did not chase you. I'm sorry if I already answered that, but that's correct?
No, he did not chase me.
Okay. And at all times, he remained on his property. At the most he went was maybe to his car in the driveway. Is that a fair statement?
Yeah, that's fair.
Okay. Now, the object that you said was a gun, this particular object was never fired. Isn't that correct?
Correct.
Okay. And it appeared to be a firearm just on your own experience, do you own any guns yourself, sir?
Yes.
Okay. So it appeared to be a gun, but you cannot say for a fact whether it was a real gun or a replica gun because it was never fired. Is that correct?
Of course. It appeared to be a gun.
It appeared, but you can't say it actually was a actual gun. Would that be a fair statement?
Objection sustained.
Nothing further, Your Honor.
Redirect.
Mr. Jordan, when you first saw the gun in Mr. Benefield's hand, did you believe it was real?
Yes.
Did you believe that you were in danger when you were on the porch?
I thought it was a possibility if I stayed there.
No further questions, Your Honor.
Thank you. Sir, you may exit the courtroom. Thank you so much.
Thank you.
Any further witnesses for the prosecution?
No further questions, no further witnesses, Your Honor.
Defense?
No witnesses, Your Honor.
Thank you. Is there a motion?
Yes, Your Honor. At this time, the people move to bind over on counts 2, 3, 4, 6, and 6, Your Honor. We heard from Mr. Jordan today that he went to the address of 19227 Buffalo here in the city of Detroit, County of Wayne, where he encountered the defendant, Your Honor. The defendant at the time of this incident was ineligible to carry a firearm, Your Honor, regardless of who was there, when they were there, or why they were there. The defendant had this gun when he entered the door. He was ineligible to do so based on a 2019 conviction of controlled substance delivery, manufacture, and possession, less than 50 grams. Your Honor, we heard that Mr. Jordan felt that he was potentially in danger while standing on the property and felt the need to remove himself from the situation, Your Honor. The presence of a gun and the way that it was being held in tandem with the word stated by Mr. Menefield. I don't want that, don't leave that here. I believe has provided this court with a probable cause that a crime was committed and the defendant was the one who committed it. An assault is a apprehension of an imminent battery, Your Honor. The presence of a firearm, even not pointed at someone, is enough to put someone in fear of an imminent battery. Therefore, Your Honor, I believe that the people have met their burden of proof, and I ask that this honorable court bind over on counts 2, 3, 4, and 6, Your Honor, as well as the habitual notice.
Thank you.
Thank you.
Your Honor, it's clearly a case of overcharging in this matter. Now, the fact for preliminary exam purposes that my client has a felony record and may have been at his home and at his side greeted someone in the nighttime hours, 10 or 11 o'clock at night, having a gun in his hand. Yes, he's ineligible to have a gun, and therefore, with the counts of being a felon in possession of a firearm and a felony firearm are sufficient, I would admit, just for purposes of binding them over to circuit court, which was the resolution. But clearly, in this matter, there was no assaultive action. It's just holding a gun, having a gun in your possession. When someone's coming to your own house and the person, and Mr. Menefield, by the witness's testimony, says he doesn't want that being served with some kind of eviction type of papers, is not any actions that to substantiate any type of assault being committed on the witness, Mr. Jordan, or any other person. Specifically, as the court I know noted the testimony of Mr. Jordan, at no time was the gun pointed at him, at no time were any threatening words directed to Mr. Jordan or anyone else indicating that he would use the gun unless they left. He just said he did not want the property, he did not want those papers. At no time did Mr. Menefield chase Mr. Jordan or anyone else off of his property. So it's clearly what we have here, Your Honor. There's no assault. We have an abortive attempt to serve, purportedly serve some landlord tenant papers in nighttime, and that's all that happened. So I'd ask the court to dismiss the other counts. I think it's a question of fact with respect to the felon in possession and felony firearm.
Yes?
Your Honor, I disagree with Mr. Sallin. We did hear testimony that the defendant did follow Mr. Jordan from inside of his home out and down the driveway, Your Honor, while still holding the gun. Just because it was never pointed doesn't mean that there wasn't an assault. And it doesn't matter what time of night Mr. Jordan was there. Sure, might that be concerning to some people? Sure, but that doesn't give Mr. Menefield the right to have a gun in his possession while dealing with Mr. Jordan.
Thank you. So the biggest argument that's being raised by defense counsel is as it relates to count 2. Apparently, as the record is clear, there is no moving to bind over on count 1, as we have not heard from a Yolanda Lockhart. So count 1 is, that will fall, that will be dismissed without prejudice, as there was no testimony in that regard. In like manner, I would think that it would make sense that count 4 would go along with count 1. So count 1 and count 4 are going to fail and be dismissed without prejudice. However, count 2, the argument again that was being raised is that there was no felonious assault. This is a probable cause hearing, Mr. Menefield. And the prosecution has the burden of establishing by a probable cause standard, crime was committed, city of Detroit, county of Wayne, that you probably committed that crime. It's a rather low burden. People don't like the level of burden here, but it is what it is until the laws change. The burden dramatically increases across the street in circuit court. Totally different ballgame. This in district court is an examination to determine whether or not there's probable cause to go forward. There's a question of fact here. Your argument by defense counsel he's made a great argument, but there is a question of fact. The witness testified that he believed he was in danger at the very least when he was on the porch. He was candid in his testimony that what he believed to be a firearm was not pointed at him. He appeared to be very credible throughout all of his testimony. And again, very candid in that there was no firearm that you raised or pointed at him. But the mere presence of that firearm that he was able to see, as you were obviously displeased with what he was there for, put him in a situation where he believed he was in danger until he took himself out of that situation. And so with that being said, I do believe the prosecution has met their burden here to establish as it relates to count 2. Count 2 will be bound over, as well as count 3, as well as count 5, which attaches to count 2, and count 6 will be bound over as well, which attaches to count 3. So again, 2, 3, 5, start that, 2, 3, 4, and 6 are going to be bound over. No, I'm saying it backwards. 2, 3, 5, and 6. Counts 2, count 3, count 5, and count 6 will be bound over. Counts 1 and count 4 are going to be dismissed without prejudice.
What's 1 and 4?
1 and 4, count 1 was felonious assault upon Yolanda Lockhart. There was no testimony that was heard in that regard. Count 4 was the felony firearm that attached to count 1, for which we heard no evidence. So counts 1 and 4 are going to be dismissed without prejudice. The AOI date is going to be August 18th.
Thank you, Judge.
Thank you, sir.
Have a good day, Your Honor.
You too.
Okay.
Just talking to the prosecutor.
Okay. And who else is out there? I'm not sure we have any else from the jail. Mr. Callahan? I don't know.
Good morning.
Did you receive a spot appointment?
On Lipscomb.
Yes, okay.
I'm going to put you in a breakout room with her.
That'll work.
Miss Lipscomb, are you present? I think she's connecting to audio.
Was Jenkins a Zoom exam? Corey Jenkins.
Oh, Kenny, I'm on Jenkins, I have a separate person.
Okay, I'm just trying to.
I'm Baker, yeah. I'm a Jenkins. Sorry, I heard Baker is good, I don't. I got Baker, is that
Division 1, 8th floor, or floor 1 rather. Floor 8, floor 1, I'm not sure. Floor 8. What's your name?
Deontay Adams.
Thank you.
All right. Calling parties on Adams and Mitchell, case number 2159564. The people of the state of Michigan versus defendant number 1, Keontae Adams. The defendant is charged with count 1, police officer fleeing third-degree vehicle code. Count 2, police officer fleeing third-degree vehicle code. Count 3, police officer fleeing third-degree vehicle code. Count 4, police officer fleeing third-degree vehicle code. Defendant number 2, Eric Mitchell, is charged with count 3, police officer fleeing third-degree vehicle code. This matter be scheduled for a probable cause conference.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Jacob Slosky on behalf People, P83677.
Marty.
Morning, Your Honor. This is Attorney Susan Dunn, P58696. I represent Mr. Adams.
Good morning,
Thank
Your
you.
Honor. James Humphreys,
Mr.
P3.
Adams, thank you, I'm sorry. Mr. Adams, can you please state your name, sir?
Deontay Adams.
Thank you. Mr. Humphries?
Good morning, Your Honor. James Humphreys, P38930 on behalf of Mr. Eric Mitchell.
Mr. Mitchell, please state your name.
Eric Mitchell.
Thank you. Okay, counsel, what's your pleasure? Ms. Dunn?
Your Honor, I apologize to Mr. Adams. I didn't know you were in jail. My appointment indicates a personal bond, so I'm assuming you have some other holds. Is that correct, Mr. Adams?
I paid. They gave me another bond on Friday, and I paid it. I'm waiting on the tether.
Okay, you're waiting on a tether. Okay, because you have a personal bond on this case. Is that what your records reflect, Judge? 70,000 personal bond?
Mr. Adams, I see $10,000 personal bond.
Oh, it is a one. I apologize the way it's written on my appointment. I'm like 70. Okay, good. No issue there. Your Honor, I have not got discovery yet, so I'm asking for an adjourned PCC date. Mr. Slutsky has promised to send me discovery. Is that correct, sir?
Correct. Discovery, at least paper discovery, has been uploaded. I can send that to you today. There is one issue, which is I've reviewed the felony information, and I have that count one as stolen property, receiving and concealing 20,000 or more for each client. But I've also reviewed the ROA, which states that count one is police officer fleeing third. So I just wanted to bring that to the court's attention.
Okay, if there's a need for amended, please make sure you provide that. What's your pleasure, Ms. Dunn and Mr. Humphries? What would you like to do?
Your Honor, on behalf of Mr. Mitchell, I would ask the court to adjourn this matter of the probable cause conference a short time in order that I might get the discovery, because I need to discuss an issue with Mr. Slutsky, is it? I don't see him listed anywhere, so I'm.
August 4th?
Oh, there. Here, I was trying to get the count. I was texting you.
I'm sorry, sir. What's your name?
Corey Jenkins.
So, Mr. Jenkins, good morning to you. We're actually in the middle of another hearing.
Oh, my bad. I'm sorry.
No worries. Just if you could mute your microphone for just a moment. Okay, so is August 4th an acceptable date? August 4th at 8:30 via Zoom for another PCC?
That works for the PC. I'll have a stand-in counsel. I'll be unavailable for the first 2 weeks of August. So, Mr. Humphries, I'll be available for the rest of the week to discuss the case. We should have plenty of time for that, especially if I send you discovery this afternoon, which I plan to do.
If we could, and then I don't have a way to reach you because you're not on the.
Will the conversation be sufficient?
I'm sorry, what?
Is the phone conversation sufficient?
Yeah, yeah.
Oh, I'll give you a call after I send discovery.
Oh, okay. All right. That'll be fine.
So, August 4th at 8:30 via Zoom for a new PCC, and hopefully by that time, we will all be up to speed and know which direction we're going.
Your Honor, if I could ask my client a quick question. Mr. Adams, is your phone number still the one that ends in 1384?
Yes, ma'am.
I'll send you a text. Thank you.
Okay, thank you so much.
Okay, we're all set. We'll see you in a week.
Thank you, Fred.
Thank you, Anna.
Take care.
Mr. Humphrey.
I'll call you.
Oh.
All right.
Calling party on Tipton. Case, I'm not sure where our prosecutor is. Case number 21-56099, the people of the state of Michigan versus David Mitchell Tipton. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. The defendant is also charged in case number 21-56100, the people of the state of Michigan versus David Mitchell Tipton. The defendant is charged with count 1, interfering with electronic communications. Count 2, domestic violence. These matters are scheduled for probable cause conference.
Thank you. Francis, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. Sarah Kraus, P81830, appearing on behalf of David Tipton on both matters this morning. He is present. Mr. Tipton, can you introduce yourself, please?
David Tipton.
Okay, thank you so much. What's your pleasure, Madam Defense?
Your Honor, I was just provided paper discovery by Mr. Bloomers this morning. I did do a quick look through of it. I would like to request at this time 911 calls and any body cam on both of these cases.
And I will follow up with that digital. I will say, both of these cases are 2020 cases, so if the 911 was not preserved by the OIC, then we're not going to have it because I can't order it at this point because it's over 90 days. But I will see if the OIC preserved it and certainly also follow up as far as body cam and the rest.
Okay, what's your pleasure then?
Your Honor, I would like to set this for an in-person preliminary exam as Mr. Tipton is in custody.
Okay, would you like to select a date, perhaps the week of August 16th?
Sure, Judge, give me one moment. I'm just grabbing my calendar. I can do Tuesday, the 17th. I'm available all day.
$10:30, Judge.
10:30 on Tuesday, August 17th.
Thank you, Judge. And may I address Mr. Tipton's bond at this time?
Yes, ma'am.
Okay. Mr. Tipton is currently 30 years old. He has no felony criminal history. He is a veteran of the Navy. He does have a place to stay. I understand the complaining witness in this case is an ex-girlfriend, but he does have a place to stay with a friend in Shelby Township. And he does work. He's trying to open his own contracting business. He worked doing work on houses and things of that nature. He is enrolled in a school program right now for HVAC. And if he misses so many days, he's going to be kicked out of the program. I would ask for a personal bond with a GPS tether in both of these cases, Judge.
Well, wait, I'm sorry, before he responds, let me just set the stage. On 2105610, the defendant's bond is $10,000 personal. So it sounds like we're only addressing 210560099, which his bond there is set at $7,500 with a 10% provision. Is that your understanding?
Yeah.
And your response, sir?
I would object. I have tried to reach out to the complaining witness. I haven't been able to speak with them. However, I think that given the nature of the charges that we have, and now we have two files here involving the same complaining witness, I don't think a $750 bond is excessive. I don't think there's any abuse of discretion there, and certainly I think a tether is in order. So I would object to lowering that bond at the time of set appropriately given the charges and the fact this is a domestic violence.
Do you see that there's a GPS tether imposed?
I see on the file with the 7,500 10%, the ROA does say tether imposed.
Okay, let me just make sure that coincides.
Now, I don't see a tether on the personal bond case.
Madam Clerk, can I trouble you to see what the ROA says? Because on what I have in my file, 210560099, that's the 7,500 for the 10%. I don't see any mention of a GPS tether. This is the one that's signed by the magistrate.
It's entered in here, tether requirement imposed.
Okay, then, thank you. So what I am going to do is make sure that we keep that date nice and close, August 17th. The motion to reduce the bond is going to be denied. There are not only one file before the court, but two files before the court. And the nature of the allegations obviously causes concern. The fact that there's a complaining witness that is the same complaining witness on both of these suggests a possible pattern. While these are just allegations, I have to make sure that I'm acting appropriately. The bond that is set on the file of concern is $7,500 with a 10% provision, which, considering the fact that everything before the court, it's rather low. So I'm going to keep the bond as it is, and I'm glad that there was a confirmation about the GPS tether requirement. In the event that you are able to post bond, Mr. Tipton, it's important that you abide by whatever tether restrictions are in place. Particularly, keep in mind that you have to have no contact with the complaining witness, not directly or indirectly. No form of social media outreach or texting, chat, anything of that nature, nor can you have anyone else act on your behalf to reach out to the complaining witness. If there's a violation, that could be a real big problem. So please make sure you ask your attorney any questions you might have regarding your bond conditions. We'll see you on August 17th, and let's make sure any discovery issues are remedied before that time.
So what was the time again?
10:30.
10:30, thank you, Judge.
And that's for both files.
Yes.
Thank you, Judge. Mr. Tipton, I will schedule a visit with you in the jail, okay?
All right. Is it going to be
Thank
today
you.
or soon? Or can I
It
speak
will
to you?
be within the next week.
Can I speak to you now?
Judge, can I trouble you for a breakout room with my client, please?
Absolutely. Hold on, Lauren.
Thank you, I appreciate it.
Sure.
Mr. McAlpine, do you need a breakout room with your client? I think that's Mr. Tabron up on the.
Yes, that's fine, Madam Clerk. Thank you.
In the jail?
Yeah, the other jailer.
Who was that, Mr. McAlpine?
Yes. Is this Alexander and Baker?
Yes.
Okay. Mr. McRipley's on.
Okay.
Calling parties on Alexander and Baker, case number 2061941. The people of the state of Michigan versus defendant number 1, Carmela Riomir Alexander. The defendant is charged with count 1, weapons, firearms, discharge, enter at a building causing serious impairment. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3 and 4, weapons, felony firearm. Defendant number 2, Fred Douglas Baker, is charged with count 1, weapons, firearms, discharge, enter at a building causing serious impairment. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3 and 4, weapons, felony firearm. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
May it please this honorable Daniel J. Blank, B10873, on behalf of Mr. Baker. And for this proceeding only, I have the permission of Ms. Alexander to stand in for her attorney who has not appeared today. It's my understanding that is she online?
Mr. McRipley is
Oh,
there.
okay, I didn't see that. I apologize. So I don't have to stand in on behalf of Ms. Alexander. We're ready to examine.
Thank you.
Your Honor, for the record, G. Whitney McRip on behalf of Miss Alexander. I just ask the court to allow me to appear by Zoom.
Okay, do you have it? Well, first of all, let me ask you to state your name, sir. Sorry, you get to say it much louder? Okay, thank you. And your name?
Carmela Alexander.
One more time?
Carmela Alexander.
Okay, Ms. Alexander, do you have any objection to your attorney participating as your counsel in this matter while he is on Zoom gallery?
No.
Thank you. That being said, in the event that you do need to communicate with counsel, I suppose, did you discuss this with your client?
I don't think we'll get that far.
Oh, okay, all right. With that being said, Mr. Prosecutor.
Your Honor, at this time, the complaining witness, Aaron Anderson, is not present in the courthouse. He was subpoenaed to be here for an 11 o'clock exam. Without his present participation, people are unable to go forward on any of the charges as read.
Is there a motion, Mr. Blanks?
Yes.
Mr. McGriffith?
On behalf of Fred Baker, we move to dismiss here.
Okay. The matters were set for examination at what time?
11 a.m. Judge.
11 a.m. It's currently 11:29 by the court's clock, and the complaining witnesses have failed to appear according to the prosecution. Therefore, I am going to grant both defense attorneys' motion to dismiss these matters. Keep in mind, Mr. Baker and Ms. Alexander, that these matters are going to be dismissed without prejudice. And what that trailer language means after the word dismissal is that it is possible that the prosecutor can reissue in this matter. If that is confusing, or if you have questions about the how or the why, please make sure that you speak to your respective attorneys and they will explain the fullness of that possibility to you. Do you have on a GPS tether that needs to be removed, Mr. Baker?
Yes, ma'am.
Ms. Alexander?
No.
Okay, so I'm going to include that language, Mr. Baker, on your dismissal paperwork so that there's no confusion when you go to the tether unit to get it removed. And we will make sure that you have a copy, counsel. I will need Mr. Blank, I will need your signature. Mr. McRipley, do I have permission to sign your name to your order of dismissal as the moving party on your matter?
Yes, Judge Archer.
We'll get a copy to you as well, Mr. McRipley.
Thank you.
Is there anything further?
Nothing for the people, Judge.
Nothing further. Also, sign my name.
No, I'm gonna see, is there? That's the beauty of you being here.
Thank you, Judge. Have a great day.
You too. Take care, sir.
The court and staff be safe.
Okay, but don't leave just yet.
I know, I'm gonna sit out there and wait.
Pleasure to see you.
Nice to see you. And wait for the officer to bring me the order.
It'll be just a second if you want to wait right
She's
here.
gonna have it ready for you then.
What's going on with, Mr. Winter's case?
It's gonna be okay.
It's a waiver?
Yes.
Okay. What about Jenkins, Corey Jenkins?
He's not checked in.
I think they're on Zoom.
Good morning. Yes, we are. We're here. We're ready if the prosecution is ready.
Was that a Zoom exam?
For Corey Jenkins?
Yes.
My file says in person.
Do you have witnesses?
No, Your Honor. I would be asking for an adjournment.
Oh.
Okay. I'm going to, all right. And then Mr. Callahan is, I think, back on this matter. All right. I'm gonna call this Stocks matter. Here you go, Mr. Blank. Calling parties on Jenkins. Case number 200627301. The people of the state of Michigan versus Corey D. Jenkins. The defendant is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Habitual offender for defense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. The Honorable Staff, Quentin Docs, P number 79657, on behalf of my clients, Mr. Corey Jenkins, will appear via Zoom and consents this hearing via Zoom, Your Honor.
Thank you. Please state your name. Can you unmute and state your name, sir?
Corey Jenkins.
Thank you. All right, today is date and time set for an examination. Are we proceeding to an exam?
Well, Your Honor, for starters, this was an in-person exam, scheduled to be an in-person exam. As the court could see, Mr. Docs and Mr. Jenkins are not here in the courtroom. However, when I sent out reminder emails yesterday, I received one back from a necessary officer witness that he was on furlough and he would not be able to attend today's date. Yesterday was the first date and time that I had heard of this furlough. Actually, I didn't see it till this morning, Your Honor. So the people would not be prepared to proceed. But given that the defendant and Mr. Dox is not here in person either, and this was scheduled for an in-person exam, I'd ask for an adjournment.
Okay, well, I guess it begs the question, why are you not in person?
Oh,
Did you
Your
think it
Honor,
was-
yeah, I honestly thought it was a Zoom that was online. My client had expressed that and he felt comfortable with that. We did not think it was an in-person exam from the very beginning, Your Honor. My client consents his statutory right to have it by hearing by Zoom, so we're ready to go.
Okay, well, so yeah, we are very careful in planning examinations to the extent that it's not really, well, it is optional. It's optional, but at the conference is when people state their preference. And if it's going to be an in-person exam, it's going to be an in-person exam. And the witnesses are a defendant and everybody's required to be here. If it's going to be a Zoom exam, then I ask certain questions. I voir dire the defendant to make sure that they are waiving their right knowingly and voluntarily. And then it's set for a Zoom exam. This court at least does not give an option on the date of the exam to switch either way. And we do this so that we can maintain some level of control and make sure that there's no objection from the prosecution. So that does explain, I do understand why you're not here now. And certainly with this age that we're dealing with in terms of Zoom court, it can be confusing, particularly when this exam was set back in January, some time ago. I can understand how there's human error that perhaps you thought that you could proceed via Zoom. So I'm not going to penalize your client in that regard. However, the superseding problem right now is that the prosecutor does not have their witness indicating that the necessary witness is on furlough. Now, Madam Prosecutor knows how I feel about this. On the date of the exam, relying on that sort of representation and asking the court to find good cause, I certainly have no problem granting adjournments when there's some level of a heads up. But this is becoming such a repeated problem. I think we just dealt with this yesterday or the day before, with officer being on furlough on the date of the exam, or at 4 o'clock the day before the exam, coming to the prosecutor's attention. I don't know if perhaps there's something that needs to change in terms of when those reminders go out to the witnesses. Perhaps it needs to be done at the very least a week or 2 weeks beforehand, so that if there is a problem, there can be a reconfiguration of the dates. That's number one. I mean, we're all trying to navigate through this pandemic era the best we can, and it's caused some tricky issues that have continually been rearing their ugly head. I don't want to waste anyone's time here. But given the fact that defense counsel and the defendant are not present here in court, defendant is out of custody, he's out on bond, I am going to grant this motion to adjourn. The tricky part is that we cannot adjourn anytime soon. We've got in custody matters that we're dealing with, and I'm going to ask Madam Clerk to find a date. I think the earliest we can do on a reschedule is October. Is that right? Yeah. And this is going to be for an in-person examination. If you want a Zoom exam, that's fine, but we need to talk about that right now, and I need to voir dire your client right now. But a Zoom exam is not going to hasten the exam date.
Judge, we can do October 20th at 10:30.
October 20th at 10:30?
Yes, Your Honor. May you voir dire my client for a Zoom exam? I appreciate you.
Okay, but again, keep in mind, that's not going to alter the timing of the exam date. Mr. Jenkins, do you understand that you have a right to a preliminary examination in person, inside of the courtroom?
Yes.
First of all, Mr. Jenkins, I can't even see you. Oh,
I'm out.
okay. Okay, good morning to you, sir. I understand that you have a right to a preliminary examination.
Okay.
Yes or no?
Yes.
And can you show me your, you know,
The speaker on this phone is kind of messed up, so that's why I keep doing this when I talk.
okay. So do you understand that that preliminary examination, the right that you have is also to have it in person, inside of the courtroom, so you can eyeball your accusers? You understand that?
Yes, ma'am.
And counsel has indicated that you want to have a Zoom exam in this matter. Is that true?
Yes, ma'am.
And that would mean that you would be appearing on Zoom just as you are right now. We would have to see your full, entire face. Do you understand that?
Yes, ma'am.
And your attorney would likewise appear via Zoom. Any witnesses would also appear via Zoom. Do you understand that?
Yes, ma'am.
Prosecutor would likely be inside of the courtroom here, and you would see them just as you do right now at the podium. Do you understand that?
Yes, ma'am.
And so in the event that you would need to communicate with your attorney, you would not be able to lean over in the traditional sense if you were present in the courtroom. You understand that, sir, right?
Yes.
And you would have to get my attention. There's a little device where you can actually show a raised hand, and I would put you in what's called the breakout room. Do you understand that?
Yes.
Okay, so given all that I've indicated, which one more thing is that the burden on the prosecutor would still remain the same. They still would have to establish by probable cause standard, crime was committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. Do you understand that?
Yes, ma'am.
Okay, so the $1 million question is, do you waive your right? Do you give up your right to an in-person examination to have a Zoom exam instead?
Yes.
Thank you. That being said, I find your waiver to be knowingly and voluntarily given. The matter is going to be set for a Zoom exam on October 20th at 10:30.
Thank you, Your Honor.
Anything further?
No, Your Honor.
Ms. Prosecutor?
Well, Your Honor, as this court knows, I'm not a fan of Zoom exams, and I would prefer not to have a Zoom exam unless there is a medical need for one. I find that there are issues with being able to hear and adequately provide a transcript. Again, unless there's a medical need, I would object.
Okay, so the instruction from the chief of this court, and really beyond that, from the Supreme Court, is to hold Zoom virtual court as much as we can. In this courtroom, we can't do as much as other courtrooms, which are doing mainly everything online. But if the defendant was in custody, I would be a little bit more troubled if out county or MDOC, because the cameras seem to be far away. I've already indicated and asked questions of the defendant as to whether or not he can show his face as it appears right now. And assuming that we have no audio issues, I'm not going to have an issue with it. Now, on the date of the exam, we don't hear, we have technical difficulties, that's something different. But I'm going to allow, in this particular case, for us to proceed with the Zoom exam. And certainly if there are issues that arise, we will cross the bridge when we get there. We're not just going to forge ahead in the event that there are some issues that are making things difficult to either hear or facilitate from any angle, whether it be from the court's angle or the prosecutor or the defense's angle. So your objection is duly noted. We are going to set this for an exam. Please make sure that your witness, Officer Johnson, has a device for which to utilize and that he can be in a room by himself. If his report is there, that the report is turned over and only referred to if needed to refresh recollection. And again, to Mr. Jenkins, please make sure you have a device that you're not going to have to bobble around too much so we can see your full face.
Got you, ma'am.
Okay, counsel, is there anything further?
No, Your Honor.
Thank you. Madam Pro, are you sure? Are you sure, Mr. Dox?
He got a little smirk on his face, thought he?
Mr. Dox is trying to get off of this call. Okay, prosecutor, anything further?
No, ma'am.
Okay, we're all set. Good to see you, Mr. Dox.
Good to see you, Your Honor, your honorable staff. Thank you.
Okay, are we? Not sure if Mr. Callahan's ready on to go back.
Are you ready on? Oh, you're all set, sir. You can log off.
Okay, thank you.
Mr. Callahan, are you ready?
Yes, I am, Your Honor.
Okay, this is a recall of People versus Anaya Lipscomb, 1-805-9583. This case was already formally called. Can I have appearances again? Or I guess a new appearance, includes your defense counsel, but Madam Prosecutor?
Good morning, Your Honor. Bryn Bailey on behalf of People, P84009.
Good morning, Your Honor. Evan Callahan, P30564 on behalf of Ms. Lipscomb, who appears via Zoom and consents to these proceedings being conducted thereon.
Okay, thank you. Could you state your name, Ms. Lipscomb?
Anaya Lipscomb.
Thank you. Counsel, what's your pleasure?
Judge, I'm going to ask the court to adjourn this PCC and allow me to get discovery so we can make an intelligent decision as to whether we're going to hold or waive an exam.
Okay, how about, you want 2 weeks out?
That would probably be good, Judge.
Okay, do you want to set it for the 11th of August?
The 11th of August would be perfect, Judge.
All right, August 11th at 8:30 via Zoom will be the new PCC. I do find good cause to grant that so that you can get the discovery, review it, and also discuss that with your client.
I will be sending you the discovery momentarily, Mr. Callahan. If you have any issues, please reach out and let me know, okay?
Will do. Thank you very much.
Thank you so much.
Calling parties on Easley.
Right.
Case number 2062585, the people of the state of Michigan versus Delina Dawn Easley. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault or assault and battery. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of People, P84009.
Good morning, Judge Archer. William Winters, P35975 on behalf of Ms. Easley.
Good morning to you, Mr. Winters.
And to you.
Could you please state your name, ma'am?
Easley.
Thank you. Okay, today is the date and time set for a preliminary examination. It's set for 9:30. Are we proceeding to one?
Your Honor, I've had a chance to speak with Ms. Easley as well as with the assistant prosecuting attorney, Ms. Bailey, who indicates that the complaining witness is present or ready to proceed. Now, I have spoken with Ms. Easley about her absolute statutory right to hold a preliminary examination, a burden that would be placed on the prosecution. Ms. Easley understands that by waiving or giving up her examination, she will be bound over to the circuit court, also known as Frank Murphy. The form that she'll be signing, I believe, says, number 1, I have the right to hire an attorney. Number 2, if I can't afford an attorney, of course, I'm going to appoint one for you. That's me, Winters. Number 3, I have the right to have this examination, but it must be proven that the crime is committed and probable cause exists to charge me.
Yeah.
Understand all that, Ms. Easley?
Yes.
Okay.
Is there any objection to the proposed waiver?
There is not, Your Honor.
Okay, Ms. Easley, you understand the allegations against you?
Yes.
And Mr. Defense Counsel already went through all the particulars, but basically you understand you have a right to preliminary examination, correct?
Yes, I do.
And that if the matter did proceed to an exam, prosecutors would need to establish by probable cause standard only. Crimes were committed, city of Detroit, county of Wayne, and that you probably committed those crimes. You understand that?
I do understand.
And if they were able to meet that burden, then the matter would be bound over. You understand that?
Yes.
And with the representation made by your attorney that you wish to waive your right to an examination, give up your right to an examination, that would mean that this matter would automatically be bound over to the circuit court. Do you understand that?
Yes,
And is that still how you wish to proceed?
yes,
Thank you. Are you doing so voluntarily?
yes.
Thank you. With that being said, I do find your waiver to be knowingly and voluntarily given. I've handed up to Madam Clerk an examination waiver form that needs to be signed by defense counsel and yourself. And the AOI, the matter is now bound over to the circuit court. The AOI date is going to be August 18th. August 18th at 9 a.m. Anything further, Mr. Winters?
No, Your Honor, but thank you very much, and thank you to your most efficient clerk also. She's one of the best in the building, as I probably told you.
Mr. Winters, I need to ask you a question too, if you, off the record, if you could come closer. Yeah, Madam Clerk is outstanding.
Thank you, thank you.
She has the ability to multitask on a level that
Yeah,
not
the
many
clerks
can
do
do.
not only this building, but just about any courthouse.
Yeah.
The clerks run the court.
Okay.
So I guess we can call Tebron. Do we have the parties here on Patrick Henningberg and Dean? That was scheduled for 11:30. Let's do Mr. McAlpine. Calling parties on Ron, case number 2159588, the people of the state of Michigan versus Timothy Levi LeBron. The defendant is charged with count 1, weapons, firearms, possession by felon, count 2, weapons carrying concealed, count 3, weapons, felony firearm, habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Judge. Warren McAlpine, P number 52522. I'm here on behalf of Timothy Tabron, who is present appearing via Zoom from the Wayne County Jail.
Okay, sir, please state your name.
Timothy Tabron.
Thank you. Thank you. Mr. McAlpine, what's your pleasure?
Your Honor, we'd like to set this matter for a Zoom preliminary exam.
Okay, and your client is in custody, so would you like to select a date the week of August 16th?
August 16th. Judge, I have 4 exams. The only day that I'm available would be on the 17th, and that would be late in the morning, if that's available.
Hold on 1 second. I'm sorry, say again?
I said the only day that I'm available on the week of the 16th is on August 17th, late in the morning.
Late in the morning? That's
Yes.
right.
Okay,
Okay. All right, so August 17th at 11:30.
that's great. That should work.
August 17th at 11:30. Now, I just need to ask you a few questions, Mr. Tabron. And this is actually distinguishable from, and I think I said this on the record earlier when there was a request for Zoom. My concern of Zoom exams are the ones wherein the individuals are in MBOC. It seems like the cameras are always way far away or out county courts, but the defendant is, the record should reflect, at Wayne County Jail, and his face is, the camera is directly in front of his face. But I do ask, as a matter of course, I'd like to get everyone's input. Do you have any objection to the proposal for a Zoom exam?
No, no more.
Madam Prosecutor?
No.
Okay, so I just need to ask you a few questions, Mr. Tabron. Do you understand the allegations against you, first of all?
Yes, ma'am.
Do you understand you have a right to a preliminary examination that is held here in person, inside of the courthouse?
Yes, ma'am.
And what's been suggested here by your attorney is that you want a Zoom exam. Is that true?
Yes.
And do you understand that that means you would appear just as you are right now, as would your attorney and witnesses appear via Zoom?
Yes.
And in the event you needed to communicate with your attorney, you would need to alert the court, and I would put you in what's called a breakout room. Do you understand that?
Yes, ma'am.
All right. And so the $1 million question is, do you give up your right to an in-person exam to have a Zoom exam instead?
Yes, ma'am.
Thank you. So Zoom exam is going to be August 17th at 11:30 in the morning. Any concerns regarding discovery?
Your Honor, I have all the discovery. I don't know if there's any digital available. Madam Prosecutor?
I believe I sent everything. I will double check that with the, for you and resend anything that I have momentarily.
Okay, that's fine. And Your Honor, before we go off the record, is it possible to address bond?
Sure.
Mr. Tabron did have a $100,000 10% bond. Unfortunately, he was remanded by the judge in the Lincoln Park District Court. Currently, again, he has no bond. I would ask the court to consider setting a bond with a GPS tether. He's a longtime Southfield, Michigan resident. He resides there with his fiance. He has one child, a 15-year-old, who he also cares for. He works for an audio-visual company. He will follow the requirements of the bond, and I don't believe he's a flight risk or a threat. And for that reason, I would ask for the court to set a reasonable bond.
Okay, I'm confused. I have $1,000 personal bond here.
Well, Judge, he was remanded. He has another case out of Lincoln Park District Court. And
okay, well, then I wish him well in front of Lincoln Park Judge. I can't alter another court's I can't alter another court's bond.
Well, Your Honor, I'm asking for a DSU.
Oh, well, okay. I can grant that, but again, the hangup appears to be with Lincoln Park. So the bond here, just so your client fully understands, is $5,000 personal bond, which means no money is required.
Okay.
So any concerns that you have with bond has got to be with the Lincoln Park.
Okay, that's fine, Your Honor. But I'd like to get the DSU.
Sorry, it does look a little confused. So please make sure you explain that we don't handle everybody, like a different jurisdiction. I don't have authority to go in there and alter their bond. So I don't think he quite understands that. So please make sure he knows what's going on here. And we've got a Zoom exam set for August 17th. I certainly can make a referral for DSU, but again, even when we get that report back, that's not going to have any effect on us.
Yes. Well, Your Honor, that was the issue when we had the preliminary exam. It was my understanding that he did have a personal bond, and then I was told that he was remanded. So that was the confusion.
Okay, so it sounds like you might need to make a phone call to Lincoln Park and get on their docket.
All right. Thank you.
Pleasure. Thank you.
Mr. McElpine?
Yes.
Would you be willing to stipulate to the prior conviction from 2013 for CCW.
Is that correct, Mr. Tabron?
Yes, sir.
Yep, okay. Yes, we'll stipulate to that.
Thank you, sir.
Thank you. All right, thank you, Judge.
Thank you. Take care. Be
You do
safe.
the same. Take care. Bye.
Okay, so what on Patrick Kenningberg and Dean?
Dean is here, his attorney is here. We haven't heard from the attorney at Hindenburg or Hindenburg.
All right, well, I guess I'll call Dean then, Judge. Were they both set?
They're both lively.
Judge, I'm going to call, just real quick, and then see if I can get a hold of the council on that, so at least we can enter the case gets in.
Okay.
I didn't realize that in here. Recalling Eric Mitchell, case number 2159564. The people of the state of Michigan versus Eric Mitchell. This case was previously called in full. I believe they would like to address bond.
Okay, appearances, please.
Good morning, or good afternoon, Your Honor. Jake Rostowski on behalf of the people, P83677.
Good afternoon again, Your Honor. James Humphreys, P38930 on behalf of Mr. Mitchell.
Good afternoon, Your Honor. Eric Mitchell.
Thank you. Counsel, what's your pleasure here?
Your Honor, we came back because Mr. Mitchell indicated that he has a home confinement tether, and that he asked me to ask the court if the court would consider granting him some hours, in that he has a newborn child at home and he needs to get that child to various doctor's appointments, as well as he needs to try to find a job. He was in the process of securing employment, and he would like to continue that process so that he can get employed.
The
prosecution?
We would not object to amending the bond to allow Mr. Mitchell to make medical appointments for either himself or his son. We also wouldn't object to amending the hours to allow him to secure employment, and specifically for that employment, but I would ask that the court tailor that language for those activities in particular.
Okay, well, I'm gonna ask Mr. Humphreys for you to tailor that language in a proposed order.
Okay.
And the hours being 8 to 5.
8 to 5.
And the proposed order should again include the language permitted to have these hourly amendments so that he can seek employment and tend to any medical appointments, family obligations, etc. In the event that he does seek employment and the hours need to be adjusted, please do notify the court and we will adjust it accordingly. And if you could forward that proposed order to Madam Clerk, she will hand it to me once she receives it, and I'll sign it and send it back to both parties.
Okay. Earlier the court's email address was in the chat, and it's not in this one. So if it could be placed there again, I can email it over real quick.
Should still be there.
It's not at the top.
It's no, I guess whenever you come in, whatever set you come in on, then the chat doesn't carry forward.
If you'll look up that waiver form I sent you earlier this morning, my email be attached to that.
Waiver. Oh, okay. I may have deleted it already. Okay, all right, y'all. If not, I'll call you back.
All right, I'll send it to you.
Thank you.
Thank you very much, Your Honor.
Thank you.
You're welcome.
Thanks, everybody.
I can't get a hold of Ms. Reed, so I'm not sure what to do with this. I'm not sure what Mr. Clements.
Oh, Mr. Clements, what are you here for, sir? Mr. Clements, what matter are you here for, sir? I don't know. Okay.
I'll call the party that's here. I'm trying to email. Calling parties on Dean, case number 2060725, the people of the state of Michigan versus Teron Dean. The defendant is charged with count 2, weapons, ammunition, possession by felon. I'm sorry, scratch that. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carrying concealed. Count 4 and 5, weapons, felony, firearm. Habitual offender, second offense notice. Commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good afternoon, Neighborhood Defender Service by Lauren Anderson, P85191, on behalf of Mr. Dean, who is present in court.
Please state your name.
Teron Dean.
Thank you. Okay. Wait, I noticed that, oh, okay, I'm sorry. This was the matter that you were telling me about, Madam Clerk, right?
There's 2 defendants, yeah.
What's your pleasure?
Your Honor, at this time, the people are not prepared to proceed to preliminary examination. So for Mr. Dean, for Mr. Dean, the co-defendant, Mr. Patrick Hennenberg, is another matter, Your Honor. However, today the people are unprepared to proceed. Subpoenas were sent, a reminder email was provided, and no officers have appeared.
Okay, is there a motion?
Yes, Your Honor, on behalf of Mr. Dean, we move to dismiss.
All right, it is currently 12:06. This matter was set for an 11:30 examination, and with those representations placed on the record, I am going to grant that motion to dismiss. Please keep in mind, sir, that Mr. Dean, that while it is dismissed, it's dismissed without prejudice. And what that trailer language after the word dismissal, what that means is that it is possible that this matter can be reissued. If you have questions about the how and the why behind that, please make sure you talk to your attorney and she will explain it to you in greater detail, okay? You understand? Oh, yeah.
Mr. Dean also has a tether, Joe, that's actually.
Okay, well, I first want to make sure he understands
Yes,
the words
sorry.
that I'm saying. Do you understand?
Yes, ma'am.
Oh, okay, all right. And I will remove that GPS tether that was imposed as a result of this case. I'm going to include that language. Wait, this is Dean, correct?
Yes, ma'am.
I don't see a GPS tether.
I got it on my list.
Okay, hold on. Can you double check? Because apparently sometimes they do miss the note. You do understand, counsel,
Yes,
it's not really just that simple of a matter. Sometimes other courts impose GPS tether.
Yes, ma'am.
And I can't remove a tether from another court. So I'm just double checking to make sure, because
I
it's
don't-
not reflected in the notes here.
It's
Do you
not-
have another pending matter?
No, I was on probation.
And did they impose the
Yeah,
tether?
yes, they did.
Okay, so you will need to take that up with that entity that imposed it.
There was not a tether ordered on this case.
Oh, no, it was for my violation.
Okay, we'll deal with that.
Okay. Thank you, Judge. So I do need your signature on the order of dismissal as the moving party. I would remove the tether if I could, Mr. Dean, but I didn't impose the tether. So I cannot remove a tether that I did not, or I don't have jurisdiction over. So I'm gonna hand this up to Madam Clerk for signature, and we are all
Is
set.
this your case, or are you just standing in for Blake?
It's mine.
You're not even sure. I think it's probably because
Didn't we have you earlier
We
today?
did several times, yeah. Judge King actually called the state bar the other day. They can't, they have my bar number, just whatever system you guys have.
They
Doesn't have
haven't
any.
updated. There's a lot of things I can't do that. Mr. Clements, did they appoint you on Damian Daniel?
No, I don't do appointments, but I can handle whatever you guys need. If something is needed, I can take care of it.
Okay, I just didn't know, I was trying to figure out why you were here with us.
Oh, I wanted to make sure that everyone received the motion that I filed yesterday for my case that's up next week. So that's why I was zooming in.
Oh, we thought you were just hanging out with us here today.
Check on us. Yeah, I
I
don't
mean,
know.
I'm happy to do that, but I just wanted to make sure that everyone, both Ms. Bailey and the clerk, received the email with the motion attached.
What's the name, the defendant's name?
I was in receipt of it, Your Honor. I can look it up. However, we didn't address defendant one, Devontae Patrick Henningberg.
Oh, yes, wait, hold on though.
We're still working.
We
I'm
just
still trying to
pivoted for
figure
a
it out.
second because we had Mr. Clements here. He was commanding our attention. Mr. Clements was muted though when I was asking for the name of the.
Oh, sorry,
defendant.
Terrence. The defendant's name is Terrence Hicks. We're on the docket for exam next Wednesday at 9:30 for 2 cases.
Terrence Hicks. Did we have that motion?
The one that I see, Your Honor, that was sent to me was not also sent to the court.
I sent it to the court and then I sent it to you, Ms. Bailey, separately, I didn't want to be on the same email chain, but
Yes, I am in receipt of it.
okay, very good.
I don't see it in my email either. Can
you
send it directly to me?
Yes, that's fine.
It's roberta.archer@36, you know the court's address, right?
Yeah.
36th districtcourt.org.
And me as well. I mean, I don't see it.
Yes, and to Tammy too, so she can make sure I don't overlook it.
Okay, I just forwarded you guys the email as well with the attachments.
Oh, I see it. I did get it. You didn't send it. I'm looking for your name, but someone else sent it.
Yes, my law clerk.
Okay.
All right, have a good day, everybody.
I see it now, thanks.
All right. I'm not sure.
Wait, did y'all need me to do something or no?
Nope.
I don't know.
Well, I don't know, do we? Can he stand in for Miss Reed? What was happening with that case?
Miss Reed or her defendant didn't show up, so I guess it's just a capias. And
that's unusual that Miss Reed wouldn't show up. I'm just wondering if there's some confusion. Her client's out on bond?
Yes.
I don't know. Can we hold this over till tomorrow? If she's not responding?
I mean, I sent an email.
We're all set, Mr. Clements.
I guess so. I'll just schedule it over for a probable cause.
Yeah, this happened last week with Mr. Margolis, and he came in the next day and realized it was just an error in the calendar. I just don't want to capias.
Judge Archer's court from Tammy.
Someone if it's not warranted.
Yeah. Oh, okay.
Back at 1:30?
1:30, yes.
1:30.
Oh, okay. All right, no problem. All right. Okay, bye. And then I called to get NATO, and they were either gonna contact him or get another attorney to zoom in. If he zooms in this afternoon, I'll let you know, Miss Bailey, what happened, okay? On Daniel?
Yeah, what about, Mr. Kinney on Hannibal?
That has a new date of just another probable cause date.
Okay.
Let me find it. What's his last name?
F-U-Q-U-A-E-Y.
I believe that it's another probable cause of August 18th.
Okay.
I just didn't have time to email you.
No, that's okay.
Yeah, and I'm wait, don't leave yet, because here's the attorney on Damien Daniels.
Oh, sweet.
And then we'll be finished. Let me find it. Calling parties on Daniel, case number 2158453, the people of the state of Michigan versus Damian Darrell Daniel. The defendant is charged with count 3, police officer assaulting, resisting, obstructing, habitual offender, second offense notice. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
And Scott Nadeau on behalf of Damian Daniel P64316.
And your client?
I'm Damian Daniel.
Thank you. What's your pleasure, counsel?
I believe we'll just have to set this for an exam after I reviewed the discovery.
You said you would like to set it for an exam?
Please.
Okay, your client is not in custody, so.
Judge, the co-defendants, we scheduled their exam for
December 7th at 10.
yeah. So I'm not sure if social distancing, I'm assuming will still be in place, so we can schedule it that same date at 11.
What time is it set for?
The other two co-defendants are scheduled at 10:30. 10:30. Nothing's written in there
What date?
yet. Oh, I didn't even have time to enter it yet.
What date was that?
Well, we're just trying to figure out how we're going to accomplish it because we cannot do a 3-bagger necessarily if we're still under the same restrictions, COVID restrictions. But what time?
Things are going south right now pretty quickly with respect to COVID.
Yeah.
All right. Well,
The other two co-defendants are scheduled at 10. If we could schedule that at 10:30 or 11?
11. Can you make it at 11 on December
7th?
December 7th?
hang on. I would imagine that's pretty far off. December 7th or 11th? Not the 11th. The 11th is Saturday. 7th?
December 7th at 11?
Yeah, we may be able to work this out before then. If the prosecutor wants to have a discussion off the record, I would entertain that.
Okay.
That's before you, right, Judge?
Yes. Any discovery concerns?
I didn't hear that.
Any discovery concerns that you have?
I don't know if there's any video, but I do have the discovery, the paper discovery.
Everything should be included in there. I will double check on that and and make sure that if there is video, and I'll just resend the link.
Okay.
Yeah, if there's any video, then fine. I mean, there should be body cam, but I don't know how much it's going to show. It's going to be kind of there's a lot of tussling.
Yeah, I'll make sure that you have whatever we have available.
Yeah, my client seems to be the least of the three defendants, if there is such a thing. The others seem to be more primary characters, primary folks. All right, so if you want to have a discussion, Ms. Prosecutor, I'd be willing to talk. I can give you my cell phone if you like.
I'll reach out.
Okay.
I don't want you handing my cell phone on live.
Okay, not a problem.
But I'll reach out.
Thank you.
Thank you.
Counsel, you sound so laid back. Are you on vacation?
No, it's funny. I had a homicide examination this morning that ended up getting put off. Because the judge wasn't available at the last minute when I'd already prepared. So that's probably, it's kind of a.
Yeah. Your mind is, I get it.
Yeah, and I'm kind of, now I have this kind of open space in my day that I'm trying to sort through. But I do appreciate it.
We'll see you in December.
Yeah, and this time I put it in my calendar. I must have neglected to do that at the last hearing for today, so I do appreciate the phone call. It was very nice of your clerk.
She's awesome.
Yes, indeed. Thank you. So I will see you guys December 7th. I do appreciate it. Maybe I'll show up a little early since the Cody's are early, and maybe we'll have if necessary. Okay.
Okay.
Thank you.
Thank you. Take care.
Bye now.
So I'll just kick this over, this Patrick
Yes, could you
Kennyberg,
please?
another property to tomorrow.
reading on here? You step out, sir.
This is Johnson, right? Yeah. Calling parties on Johnson, case number 2156899. The people of the state of Michigan versus Daryl Henry Johnson. The defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, 3, 4, and 5, assault with a dangerous weapon, felonious assault. Count 6 and 7, weapons, felony firearm. Count 8, 9, and 10, weapons, felony firearm. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good afternoon, Your Honor. Matthew Makepeace on behalf of the people, T82796.
Good afternoon, Your Honor. Here, Chief Court Brooklyn Johnson appearing on behalf of Daryl Henry Johnson.
Mr. Johnson, oh, sorry, your P number?
P46646.
Thank you. Your name, sir?
Daryl Henry Johnson.
Thank you. All right. Are there any preliminary matters to tend to?
Just one, Judge. This is, as the court's well aware, a continued preliminary exam. At the last exam, there was an officer in charge who was made an exception from the order of sequestration. That was a stand-in officer in charge. I would ask that the court allow police officer Emily James to be in the courtroom during the proceedings. I spoke with defense counsel about this prior to.
No objection.
Okay, then that will be the case. That officer in charge will be able to remain in the courtroom. Is that officer in the hallway right now?
She is, Judge, yes.
Okay. Anything further? And again, sequestration will continue. I do want to point out that there are, well, the record should reflect that the courtroom is already restricted due to the COVID restrictions that are still in place. However, as I look at the Zoom gallery, there are a few people here. I'm not sure why they're here. Breezy. I've got Breezy, Miss Moore, Joe, Otis Coyle. If those that are in the Zoom gallery, if you wish to remain in the Zoom gallery, please identify yourself so that we can make sure there's no objection to you being present in Zoom gallery.
Yes.
I've got Breezy, Miss Moore. I need individuals to identify themselves by stating their name.
Joe Williams.
Any objection?
What was the last name, Judge? I didn't.
Last name, sir?
Williams. Joe Williams.
Any
Stepfather
objection? Stepfather of what?
Otis Coyle.
Okay, any objection from the prosecution?
No, Judge.
Any objection from the defense?
No, Your Honor, I remember this case from last time.
Okay, thank you. And we've got anyone else? I see there are people here. If you don't identify yourself, I will have to put you in the waiting room. Okay, so the remaining individuals going once?
Breezy.
However, as I look at the Zoom gallery, okay, their name?
This is Coyle's cousin.
Any objection, please?
Judge, did she place her name on the
What is your name?
Brienne is under Breezy.
Miss Moore, Joe. What is?
That shit gonna kill my back. My back gonna be dead.
What is your name? Okay. There's a device titled Otis Coyle. What is your name? Please identify yourself. Okay, well, we're not making much headway there.
Otis Coyle is Otis's father.
Individuals. Any objection, Mr. Makepeace?
No, Judge.
Any objection, Mr. Johnson?
No, Your Honor.
Okay, so Joe and Otis Coyle may remain. Breezy, thank you for being helpful, but we still did not get your name.
My name is Brienne Wells.
Otis Coyle.
Okay, any objection to the prosecution?
No, Judge. Any objection from the defense? No, Your Honor, I remember the change.
Okay, I'm gonna ask one more time. Eliminate your background noise, which sounds like you're watching the live stream, and please state your name. Okay, so I'm gonna put you in a waiting room.
Judge, on Otis Coyle's father, he didn't identify himself though.
The device titled Otis Coyle, could you please,
Face, I'm sorry.
could you please identify yourself and show your video, please? The device titled Miss Moore. Same query. Can you identify yourself?
Put the video on there?
Okay. What is your name? Thank you. What is your name?
Babe, tell her your name, babe.
Four.
One more time. Elisa Moore. And who is in the room with you? Are you, I see there looks like there's.
I'm the deceased mom.
Okay, are you in a room by yourself?
No.
Okay, so we have.
Brother, my sister, and my son.
Mr. Makepeace, Mr. Johnson.
I object, Your Honor.
You do object?
Yeah, I mean, she's in a room full of people.
Okay, Ms. Moore, could you identify again who is with you?
It's just myself. My mother, my brother, and my sister.
And their names?
Douglas
Moore, Johnny May Moore, Demaria Walk.
Mr. Makepeace.
No objection, Judge.
Mr. Johnson.
No objection.
Thank you. The device titled Otis Coyle, could you please show your video and state your name?
I'm sorry?
The device that is titled Otis Coyle, could you please identify yourself on your own by stating your name and showing your video? Okay, I do not see the person with the device titled Otis Coyle making any identifiable statements. Mr. Makepeace, Mr. Johnson, do you want me to eliminate from the Zoom gallery?
Yes, Your Honor.
Mr. Makepeace.
Leave it to the court's discretion.
Okay. The device titled Otis Coyle. Could you please state your name, sir?
Otis Coyle. I had problems. I was trying to see what was going on. Sorry
Any
about
objection?
that.
That's okay. Any objection to him being present?
Judge, if the court could inquire as to his relationship to the victim in this case.
I'm his father.
No objection, Judge.
No objection.
Okay, Mr. Otis. L. Perry. First initial L. Perry. Does anybody know who that is?
Doesn't sound familiar to me, Judge.
Mr. Johnson?
No, Your Honor.
That person. Room? Oh, L. Perry, yes, could you state your name?
Tell me you just drink, but oh, really?
Could you please state your name?
Lena Perry,
And what is your relationship to the case?
cousin to Otis Coyle.
Any objection, Mr. Makepeace?
No objection, Judge.
Mr. Johnson?
No objection.
And there was no objection to Brianna, was there?
No objection.
Mr. Johnson? She's the device titled Greasy.
I can see her identify her.
Could you state your name again, ma'am?
Brianne Wells.
And your relation to the case?
I'm Otis's Coyle's cousin.
All right. I would just ask, we're gonna close down the Zoom gallery now. Well, not close it down, but we're not going to allow others in at this time. I would ask that everybody that's in the Zoom gallery, if you could please mute your phones. And now, well, also before we put you on mute, please know that there should not be any other individuals coming in and watching your Zoom gallery, your Zoom. There is a sequestration order, and that means that anybody that's a witness or potential witness is not permitted to watch the proceedings. So please, if you would, make sure that you keep your microphones muted and that you do not unmute and make any outbursts or use any profanity or make any commentary, really. And also, I'm going to ask now that you turn your videos off. Okay? Ms. Moore and Mr. Otis Coyle. You can still see us, we just won't be able to see you, if that makes sense. You just have to tap on the little picture of a little camera, and we won't be able to see you, but you can still see us. Ms. Moore, does that make sense? Yes? Just tap on that button.
Your screen off, babe.
Okay, hopefully you'll figure that out shortly. There you go, thank you. All right, and the third tier to the sequestration is that this is live streaming on YouTube. So if there's anyone watching the live stream that shouldn't be watching it because you're either a witness or a potential witness, as I've said a couple times here, please make sure that you stop from watching these proceedings as it may preclude you from testifying in the future. That being said, let us please pick up where we, okay. Well, I'm gonna be muting your microphone. Everyone needs to keep their microphones muted. Thank you. Okay, let's pick up where we left off.
Thank you, Judge. At this time, the people call Michael Royston.
Sir, could you please state your full name?
Michael Royston.
And can you spell your first and last name?
MRCHAELROYSTO.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please come up here and have a seat. This half gate will swing open towards you. Once he's settled, you may proceed, Mr. Prosecutor.
Thank you. Could you state your name for the record, sir?
Michael Royston.
Okay, Mr. Royston, I want to take your attention back to March 27th, 2021. Were you at a address or a location called the Jay-Z Motel that day?
Yes.
And who were you with that day?
Me, Contina, Deputy, Tommy, and Otis.
Okay. Was there someone that you knew by someone that you knew named Daryl Johnson there?
Yeah.
Okay, do you see Daryl Johnson in the courtroom today?
Yeah.
Could you point to him and identify the piece of clothing that he's wearing?
He's wearing a green shirt.
For the record, the witness has identified the defendant, in this case, Mr. Johnson.
The record will reflect identification of the defendant.
Okay, I want to take you back to the JZ Motel on March 27th. What was going on there? What were you all doing there?
We were basically just partying, that's all.
Okay, when you say partying, you mean drinking?
Yeah.
Alcohol, that is?
Yeah.
And were you doing any narcotics or drugs?
No.
Okay. That's a hotel, correct?
Yes.
Was someone in the room who had rented that room?
Yes.
Who was that person?
Quantina.
And who is Quantina to you?
My girlfriend.
How long have you been with Quantina?
Well, I've known her for a long time, but as far as us being together, we've been together for about a good 5-6 months.
Okay, and the person that you identified as Daryl Johnson, is there any relation between Daryl Johnson and your girlfriend Quantina?
Yes.
What is that relationship?
That's her son.
Okay. So you said that there was Devaney and then someone you identified as Tommy there, correct?
Yeah.
And how do you know those people?
Devaney is her sister.
Let me stop right there. You say her, who are you referring to?
Quantina.
Okay. Devaney is her sister, and who is Tommy?
Tommy is Devaney's boyfriend.
Okay. And you said that you were all partying in the room. At what point, who arrived there first out of the people you've named so far?
The first person, well, it was my room and Quantina's room, so we were there first, and Devaney came after. Actually, he came.
Let me stop right there. We need to use names. Okay. So Daryl John, when you say he, who are you referring to?
Daryl.
Okay.
He came, then Devaney, Tommy came, and Otis was the last one. He was the last person to get there.
Okay, and for the when you say Otis, do you know Otis's last name?
Coyle, I think it is.
Okay. Let me ask you a couple questions. How long had you known Daryl Johnson on March 27th?
That was the second day that I had actually met him.
Okay, when was the first day?
The day before.
All right. When Mr. Johnson, Daryl Johnson, that is, arrived to the JZ Motel, did he have anyone with him? Was he traveling with anyone?
Yes.
Who are those people, if you know?
His girlfriend and their daughter.
Okay. Was there another male or any other adults?
Yes.
Do you know the girlfriend's name?
No, I don't.
Okay. Had you ever met her before?
No.
Okay. And you said there was another adult with them?
Yeah, another male, his friend.
Do you know his name?
No.
Okay. Had you ever met that person before?
No.
All right. So as you said that you and Quantina were there, and then Daryl Johnson and his party arrived. At some point, Devaney and Tommy get there, correct? When everybody is there, what's going on in the hotel room?
Basically, everybody was just socializing at first, talking, drinking, because we were actually preparing for Devaney's birthday, because she was supposed to be renting a party bus or something like that. So we was just drinking and discussing that and everything else.
Okay, and when everybody is there, or at least the people we spoke about are being there already, what time of day is this?
It was still daylight outside. I know that. Okay. I can't exactly remember what time it was, but I know it was still daylight.
Do you remember if it was after 12 p.m. or in the morning?
It was in the afternoon. It was after 12.
Okay. So as this is going on, I want to ask you, what is Daryl Johnson's attitude at this point? Is he upset? Is he happy? Is he neutral?
At first, everything was fine. I mean, as far as I could tell, everything was all right.
Okay. At some point, well, let me ask you this. Are you hanging out with Mr. Johnson a lot? Are you talking to him?
No, I mean, I was just basically just talking to everybody. We all were talking to each other all
At some point, you said that Otis Coyle arrived, right?
Yeah.
All right, tell me about that.
Well, once he arrived, he was in good spirits just like everybody else. He started drinking with us, we were talking and just having a good time.
All right. At some point, does Mr. Johnson's girlfriend leave?
Yes, she left right after Otis took Daryl and his friend to the store.
Okay, so let me stop you right there. Up until the point when Daryl, Otis, and his friend went to the store, had you talked to Mr. Johnson's girlfriend at all?
No, not really. She basically was just mainly talking with the girls. The girls, they was talking together.
Okay.
I mean, we jump in and out of each other's conversations, but it was not like face-to-face, me and you talking, just us talking. No.
Okay, at any point before she left, did you have a chance to observe anything on her body?
No, not really. I really wasn't paying attention.
Okay, were you aware, and I don't want to go into what other people said, but were you aware of a situation that she had brought up?
I'm object to the part.
Your response?
I don't think it's hearsay. I asked, I don't want to go into any statements specifically said that in the question. I just want to know if he was aware of a specific situation.
Now, I see you're still standing. Did you want to respond to what he just said? Because I am
I'll
prepared
wait,
to rule.
Judge, because I was just protecting the record, so
Yeah.
I'll just wait.
Okay, so my response to the objection and the response to the objection is that the objection is overruled. You may ask that question. I think obviously Mr. Johnson is concerned about what that next question might be.
I think that's fair.
Okay.
I'll ask the question again. Were you aware of a specific situation, without saying what anyone said, that Mr. Johnson's girlfriend had brought up?
No.
Okay. Did you see her leave?
Oh, yeah.
Who did she leave with, if anyone?
She left with her daughter.
Okay. What about Mr. Johnson? Where was he when she left?
They were going to the store.
Okay. And you said they were going to the store. I think you said Otis, his friend, Daryl Johnson, and his friend,
And
right?
his friend, yes.
Okay. Before, I just want to go back because I forgot to ask you this. Before Otis Coyle got there, did you call Otis or have any contact with him?
Otis spent the night there the night before.
Okay.
He left early that morning and he had already said that he was going to come back. I mean, he told me and Quantina.
Object to the hearsay.
Your response?
Judge, I don't think it's super, I think it's more foundational, but in terms of what the actual statement was, just like we did last time, it's a statement of future intention, which is 803, I believe. 3 or 4, I don't have the rules in front of me right now.
Is
But
it
he's
being
stating what
offered
he's
for
going
the
to do in
truth?
the future.
Is it being offered for the truth of the matter asserted?
No, Judge, it goes to the effect on the list.
The objection is overruled.
Thank you. Mr. Coyle said he was going to come back that morning, correct?
He said he was going to come back later on that day.
Okay. And did he in fact come back?
Yes.
At the time that he arrived back at the JZ Motel, what time was it?
It was nighttime. It was dark.
I'm just gonna ask you to turn that on silent and
Yes.
put it back in your pocket.
I thought he was answering his phone.
I thought he was too, John.
I was trying to cut
I was like, well, okay.
Sorry.
No worries. It's the new rules with civilians being allowed to bring phones in, this happens. Going back, you said it was nighttime when Otis arrived, correct?
Yeah, it was dark.
Okay. Now, when Otis, and I'm just going to recap, Otis, Daryl, and his friend went to the store, the girlfriend left, correct?
Yeah.
Okay. At some point, does Daryl Johnson, Otis, and his friend come back to the JZ Motel?
Yes.
What happened when they came back?
Well, when Otis and Daryl and the other guy came back and Daryl found out that she had left, he was real angry and belligerent with just about everybody in the room. I mean.
All right, let me stop you right there. In terms of when Daryl Johnson got back, how long was it until he learned that his girlfriend and his daughter had left?
A few minutes.
Okay. And you said that he was getting angry at everybody in the room. Who was in the room at that time?
myself, Quantina, Devaney, Tommy, and Otis.
Okay, so the 5 of you plus Mr. Johnson, correct?
Yeah.
All right, so we had talked a little bit earlier that this was a hotel room. Could you describe the layout of this room?
I guess it was your typical jacuzzi room. I mean, wasn't nothing really spectacular out of the ordinary about it. I mean, bed.
Let me stop you right there. If you are standing inside the front of the door to the room that you would normally walk in, what is to your left?
The bed, the nightstand, and a couple of chairs.
Okay, what is directly in front of you?
The microwave was sitting on top of the refrigerator.
Okay, and what is to your right from the front?
The jacuzzi tub, the toilet, and the shower.
Okay, is the jacuzzi tub, the toilet, and the shower in a separate room, or is it in the same room as the bed?
It's basically the same room. It's like a partial wall kind of blocking it, but it's basically all just straight.
Okay. So you said that there were 6 total people in the room when he learned about Mr. Johnson was getting upset, correct?
Yeah.
When Mr. Johnson got upset, where were you sitting? Where were you in the room?
I was sitting on the bed.
Okay, where was Quantina?
Well, at first, she was right next to me. She was right next to me on the bed.
Okay, where was Tommy?
He was sitting directly across from me in one of the chairs.
Okay, where was Devaney?
She was sitting right next to him.
Where was Otis?
He was basically standing up off to the side in the same room.
Was he closer to the door or the bed?
In between.
Okay, and where was Mr. Johnson?
At first he was walking around.
Okay. Now you said that he was upset at everybody in the room, really. Was he saying anything?
Basically, he was mainly upset with Quantina and Deb.
Okay, what was he saying, if anything?
He was mad because they had let her go, and he couldn't understand why they let her go.
Okay, let me stop right there, because when you say her, who are you referring to?
Daryl's girlfriend.
Okay. And he was upset that they let her go. Did he say anything to you at this time?
No.
Did he say anything to Otis at this time?
Otis was actually trying to calm him down, just like Quantina, Devaney, basically everybody in the room was actually trying to calm him down and trying to get him to look at the situation in a different light.
Okay. And when Otis and the others were trying to get him to calm down, did he at some point calm down?
No.
Okay.
He seemed to get more agitated.
Okay. Was his voice raised?
Yeah.
Did he make any threats towards anyone?
Not that I know of. He was just upset.
Okay. And for this entire time, for this time that he was upset, did he stay in the room the entire time?
Yes.
All right. And did everybody else stay in the room the entire time?
Yeah.
Okay. From the point that he was that he learned and got upset, and then eventually something happened, correct?
Yeah.
Okay. Until that happened, how long was it between the time that he got upset and until the incident happened?
I would say maybe 10, 15 minutes.
Okay. And during this time, did you see a gun on Mr. Johnson?
I'm object to the speculation.
I don't think that's speculation, Judge. Just did he see
Either he
it?
did or he didn't.
Yeah. It's a
Either
yes or
you
no.
did or you didn't. If you know, you can answer. If you're not sure, then don't say you did.
Yes.
You did see a gun?
Yeah.
Where did you see the gun on Mr. Johnson?
It was on his waist.
Okay. At some point, did he grab that gun?
Yes.
All right. I'm going to come to that in a second. Did he ever touch that gun before the incident happened?
Not that I saw.
Okay. Now, the first time that he grabbed the gun then, where was he standing?
I was sitting on the bed. He was standing about maybe a foot or a foot and a half away from me.
Okay, was he closer to the bed or the door?
He was right in the middle of me and Tommy, because Tommy was sitting on the other side of the room. He was standing like, basically in the middle, you could say, in between me and Tommy.
Okay.
And I was sitting on the bed.
And where were you sitting on the bed? At the foot of the bed, the middle of the bed, or where the pillows are?
I was closer toward the pillow.
Okay. And when he pulled the gun, did he say anything?
Yeah.
What did he say?
Because Otis had told him to put the gun on the microwave. He said.
All right, so let me stop right there. Let's back up to before he pulled the gun. What was going on in the seconds before he pulled the gun?
He was still arguing, and we had already tried to get him to calm down because we didn't want to get kicked out of the room for the loud noise. And Otis was standing about 6 or 7 feet away from him or directly in front of him. He had a phone in one hand and a cup of alcohol in the other, and he was trying to tell him that he was getting ready to call him. He was gonna call some girls for them to try to get his mind off of his girlfriend. And he told him, put the gun on the microwave.
Let me stop you right there. You said that he told him. Who's he in that situation?
Otis.
And who's him?
Daryl.
Okay.
Otis told Daryl to put the gun on the microwave because nobody in the room was armed. At least we weren't.
Okay, let me stop right there and ask a few more questions about that. Did you have a gun on you?
No, sir.
Did you ever see Otis Coyle with a gun that night?
No.
All right. So, were you aware, did you see anybody else with guns that night that was there?
The only other person besides Daryl that had a gun was his friend that came with him.
Okay. Now, okay. So, did you ever see Daryl get angry towards his friend?
No.
All right. So now, you said Otis was standing with his phone in one hand, a drink in the other, and he was trying to talk to Mr. Johnson, correct?
Yes.
What happened when Otis told him to put the gun on the microwave?
He looked at him and he said, "What, this gun?" And he pulled it out and he shot him.
Okay, how long between Mr. Coyle saying to put the gun on the microwave and the shot that was fired?
About seconds. I don't know. It was real quick.
Okay. And how many times did Mr. Johnson fire?
Once.
Right. And did you see where the bullet hit?
Not exactly at first, not until after they ran out the room and he was laying on the floor.
And you say he was laying on the floor. Who is he?
Otis.
And did you see any injuries on Otis at that time?
Once he hit the floor and Daryl and his friend finally ran out, we got to him and yeah, he was shot.
Okay, where was he shot?
Shot like right here.
Okay, for the record, the witness is using his left arm to point to the left side of his chest, just under just over the rib cage area. Is that correct, sir?
Yes.
And after the shot was fired and Otis was shot, where you indicated, what happened next?
He stepped over, Daryl stepped over Otis, and he instantly turned around and he pointed the gun at everybody, like, basically, don't move or don't do anything.
Let me stop you right there.
Objection sustained.
Let's go back. You said that he pointed the gun at everybody. Who is everybody?
Me, Quantina, Devaney, and Thomas.
Okay. And you said Thomas, that's Tommy?
Yeah, Tommy.
Okay. What was going through your mind when he was pointing the gun at you?
I'm not moving. I'm not moving a muscle.
Were you scared?
Yeah. Very.
Did the others appear to be scared as well?
Yes.
Objection sustained.
What did you do, if anything, when the gun was pointed at you?
I just sat there like this.
And for the record, the witness put both of his hands up, palms out. Did anybody else do the same thing? If you don't.
I could only see Deb Devaney and Thomas, they were the same way. Quantina, at this time, she was standing up by the microwave, so I couldn't really turn and just look at her. I was more focused on him.
Okay. I don't think I asked this. Do you know Thomas's last name?
No.
Okay. You saw Thomas put his hands up, correct?
Yeah.
All right. You said that, well, let me ask you this. Did Daryl Johnson leave the room after that?
He called for his friend about 3 times as Daryl was waving the gun. He called for his friend about 3 times, and he finally got up and they ran out the door.
Okay, when they ran out the door, did you see where they went?
No, I just jumped up and we slammed the door and got down on Otis and was trying to keep him alive until an ambulance, somebody could get there.
Did an ambulance and the police eventually show up?
Yes.
Do you know if anyone called 911?
Yes, Deb called and Quantina called.
Okay. And did the ambulance show up and take Mr. Coyle away?
Yes.
All right. Now, I want to ask you, when the police showed up, did you talk to a police officer on the scene?
Yes, after they took Otis out of the room, yes.
Okay, and did you also provide a written statement to that same police officer?
Yeah.
Okay, and in that written statement, did you tell them what you just testified to?
No.
What did you tell that police officer at that time?
I told them that I was standing in the bathroom and I heard the shot and I didn't see who actually did it.
And is that what was recorded in your written statement?
At that time, yeah.
Okay, is there a reason you didn't tell them what you just told us?
Yeah.
What was that reason?
When it first happened, I was scared. I was still in shock and I really didn't want to be involved in nothing like that. So I just said that, trying not to be put in this situation.
Okay, and when you say in this situation, you mean exactly what you're doing here?
In court, yeah.
How long after the shooting did you talk to the officer and tell them that you didn't see anything?
When they subpoenaed Quantina.
No, back up, sir. That night, how long after did you provide this written statement to the officer after the shooting?
If I had to say a time, it probably would have been about half hour, maybe 45 minutes.
Okay, so half hour to 45 minutes after you saw Otis Coyle shot, you gave that initial written statement. Okay,
Yes.
and did you eventually talk to another police officer a few days later?
Yes.
And did you tell them, that police officer, a few days later, what you just told us?
Yes, I told them
the truth. And is what you told us here today the truth?
Yes, sir.
We have one moment, Judge?
Yes.
I have nothing further.
Cross-examination.
Judge, may I use the laboratory record?
Yes.
And they said that case would go back to Judge Giles.
That it would go back? Meaning to Judge Giles?
To Judge Giles.
Wait, so say again? You said it's up to you?
To, the director in docket control. He said that it would go back to Judge Giles no matter what he's assigned to now. It will, he could even want to hear it.
Okay, so it's, but it still has it, I mean, we still need to discuss it.
Right, right.
I sent a message to them.
I saw that.
Okay, cross-examination?
Thank you. Good afternoon. You indicated that, when you talked to the police, you did not tell them the truth the first time, correct?
Correct.
Okay. You were questioned by the police at least, a half hour after the incident, correct?
Yes, about that, yeah.
Yeah, and you knew the importance of the interview, correct?
Yes and no.
Well, how old are you, sir?
41.
You've been around, right?
Yeah.
You know what, that this was a serious shooting, correct? Could possibly, Otis could be dying or died, or could be en route to the hospital and died, correct?
Correct.
You knew that it could be possibly a homicide of some sort or killing, right?
I was praying that it wasn't, but.
I know, but just based on your age and maturity and coming from our community and knowing what you know, you watch the news, you see shootings, you knew that when the police came and questioned you, how important it was. Plus you knew the deceased, correct?
Correct.
And you knew how important it was for you to give them any information you had at that time, correct?
Correct.
Okay, and you said you all were drinking, right?
Yes.
Okay, and y'all were smoking weed, correct?
I wasn't.
You under oath now, it's gonna come out, so I'm just asking you, now that you understand, now that you decided to come in here and testify under oath, I'm asking you, were you all smoking marijuana or not?
People was outside going in and out.
My question is, were they smoking marijuana and drinking?
Yeah.
Yes or no?
Yeah.
Okay, so when you said there were no narcotics, that was not the truth, correct?
I didn't know marijuana was a narcotic. I thought.
At 40-some years old, with all the legislation, you don't know that marijuana is a narcotic?
It's legal.
I didn't ask you that. I said you didn't know whether it was marijuana is a narcotic?
I didn't think it was.
Okay. And you didn't smoke any marijuana? Okay.
No.
And so you knew someone had been shot, right?
Yes.
And so when the police asked you specifically, who was in the room, you told them nobody was in the room but you and Quantina before you went to the bathroom, correct?
Yes.
Okay. And when they asked you how long was you in the bathroom, you said 15 minutes, right?
Yes.
Okay, just like you just said today, and under oath, you said you gave minutes and times and seconds, right? It was no different than what you did at the interview right after the incident. You said 15 minutes, right?
Yes.
And my first question would have been, if it was the truth, was how do you know it was 15 minutes? Or did you count the time? And you would have had to say no, right? You didn't count the time, right?
I'm sorry, hold on 1 second. Mr. Rankin.
So, I mean, he can ask the question in a leading manner, but he's also now just putting words in his mouth by saying you would have had to say no.
Objection sustained.
Yeah, I'll move on. The question is, sir, I'll move on to another question. The question is, you told the police 15 minutes. We now know that was a lie, right?
Yes, at that time.
Okay, but even when you told them 15 minutes, that was not something that you had went into the bathroom and figured out in your mind, correct?
Correct.
Okay. What you do know, based on what you came in here today and said, was when he pulled that gun, he fired it in a matter of a second or so, right?
As soon as it was pulled and raised, yeah.
He fired it, right? And he didn't give a warning about that, did he?
No.
He didn't threaten him, did he?
Who?
That defendant, Mr. Johnson.
Otis never threatened him.
No, I said the defendant, Mr. Johnson, when he pulled the gun.
Oh, no.
He didn't give Otis no notice he was gonna shoot that gun, right?
No.
Nobody was expecting that to happen, correct?
Correct.
And it was just out of the blue, right? He pulls the gun, Otis says something, he pulls the gun and he shoots him, right?
Yes.
And at that time, Otis was somewhere, and I'm not gonna ask you to speculate or approximate, but what you do know is at that some point, Otis was standing in front of him, right?
Not close, but yes.
I didn't ask you close or far or whatever. I just asked you, was he standing in front of him? Yes or no?
Yes.
Because you admit you've already lied, right?
That's the answer.
Judge, it's not. I didn't ask him that question.
Objection overruled.
You admit you've already lied, right?
In the initial interview, yes.
You would admit that you've already lied, right?
That's the answer.
Objection sustained.
Told the police you didn't even see the shooting, right?
Correct.
So at that time, you wasn't trying to help Otis, were you?
I was trying not.
Yes or no? You weren't trying to help Otis at that time, right? Your friend, right?
I was trying not to end up here or shot like Otis.
My question was, at the time, after the incident, 30 minutes later, when everything had cooled down, and the police was sitting there trying to get information that would help with this investigation, you, for your own personal reasons, chose not to help Otis and give them the name or the party or the description, or at least say you saw the shooting, correct? Yes or no? Sir, I know this is difficult, but we can move through this if you just answer the question. Yes or no? When they ask you, did you see anybody with the gun? You said no, right?
Correct.
So at that time, you had chosen for your own selfish reasons not to help Otis, not to try to implicate Mr. Johnson over there, not to give them any facts to go on. You decided for your own reasoning to fabricate this statement and then sign it, correct?
Yes.
Okay. So, what you do know is that once Mr. Johnson walked over Otis's body like that and walked out that door after shooting Otis, everybody was upset, right?
Yeah.
You slammed the door, you shut the door, people called 911, everybody was trying to help Otis, assist Otis, revive Otis. You know that, right?
Yes.
You can testify truthfully to that today because you saw that, right?
Yes.
Okay. And everybody was talking, and I'm not asking you about anything that was said, but what you do know, everybody was talking about what happened. Everybody appeared to be in shock, right? That's common sense, correct?
Yes.
And that continued on for the next few days, correct? People talking, people telling about what happened, people sharing their feelings, what they saw, and their responses. That went on because everybody's close-knit, right?
Amongst us, yes.
Yes. So you agree that you had the opportunity to discuss this case with everybody in that room, correct? That day, the day after, the next day, and the next day, because this was a startling fact, what occurred, correct?
Yes.
Okay. And at no time during those 3 days, when it was fresh in your mind, before you had talked to anybody, before you had shared the facts with anybody, before you had put your story together, you did not call the police or come to the police and tell them, look, I want to give you what I know to the best of my ability.
I did.
Okay. And that was 3 days later, right?
Yeah. Whatever.
Okay.
Yeah, whatever.
Thank you. I don't have to ask you that question. 3 days later, after you discussed the case. So the police didn't write down that statement, did they?
We were down at the headquarters.
My question again is, the police did not write down the additional statement and have you sign it, right?
I can't really remember exactly.
Well, you don't remember signing another statement, correct?
I remember signing a picture and yes.
You don't remember signing another statement, correct? Just think about it. I'm not trying to confuse you. Okay, I'm not asking about a lineup or anything. I'm just saying, did they write down like they did before a statement? Well, let me ask you this. Do you recall the police asking you, was this the truth? The first statement you gave that you lied about, do you remember that?
Yes.
Okay. So they didn't take another statement from you where they went through that same process, correct?
I can't really recall.
Okay. So today, when you came in to testify, or sometime prior to today, you had a chance to talk to the prosecutor, correct? This gentleman here or another prosecutor, right?
Yes.
Right?
Yeah.
And you all talked about your statement, correct?
Yes.
And you all talked about the fact that the statement you gave was not, the first statement you gave was not the truth, correct?
Yes.
And you all talked about what that meant, correct?
Yeah.
Okay. And then you all talked about how you were gonna take the stand today and attempt to tell another story, correct?
Judge, I'm gonna object to the implication behind that question.
Judge, there's no implication. That's not an objection. And I'm not calling this prosecutor out. I'm asking him what occurred.
I'm gonna allow the question. You certainly can redirect.
Thank you, Judge.
And you talked
Wait,
about.
did you get an answer? I don't know if we got an answer.
Yeah, we did get an answer, right?
I did.
I didn't hear
I
it.
think, you don't have to worry about that. So you all talked about and tried to prepare for you to testify today, correct?
Yes.
Okay. And so what you testified today to is what you recall, correct?
The truth, yes.
What you say you saw, right?
But I know I saw, yes.
And after talking to all the other witnesses and people that were present, correct?
We talked about it, yeah.
So everything that you testified is an accumulation of all of that, correct?
No.
Or you spliced it out in your mind?
It's been burned into my mind ever since the day that it happened.
Yeah, everything that happened, right? Everything that was said, what you all talked about, what you saw, it's all in your mind and it's a part of your testimony today. Isn't it true?
Yes.
Yes, okay. Because you didn't look around the room and see who all had their hands up, right? Your eyes was focused on that gun, right? When that gun was pointed at you, you saw, you looked in the barrel. You weren't looking at him. You weren't looking at who was at that other room. You were looking into the barrel of the gun. It's called weapon focus. You were focused on the weapon, correct?
No, I was focused on him and everything that was in front of me in that area.
Okay, good. So now that we know that you can see well and we're focused, let me ask you, this was exhibit what? Two. I'm gonna ask you to look at people's proposed, may I approach Judge?
Yes, and I think it was admitted though, correct, right?
Yeah, it was admitted, I'm sorry. I'm gonna ask you to look at exhibit 2, people's exhibit 2, sir. This is and I think this was prepared by the evidence text. Am I right, sir?
Judge, it was admitted by stipulation. The person who prepared it didn't admit it. It's certainly not on the record. I don't know exactly who.
Okay. All right, I'm gonna ask you to just briefly look at this, sir, and see if that is supposed to be a depiction of the hotel room. And I just want you to look at it and see if that helps you refresh your recollection at all. And does that appear to be not accurate depiction, but a depiction good enough for you to refresh your recollection?
Yes.
It does?
Somewhat.
You think if I asked you a couple questions that would help you answer them, or would you rather not? No, just answer the question. I don't want you to start making comments on the record unless I ask you a question. Does that help refresh your recollection? Do you see a bed?
Yes.
Do you see where you may have been sitting? I'm pointing to the bed. Does that look like the bed, sir?
Yeah.
Okay, we don't have to worry about that.
Okay.
Does that appear to be the jacuzzi?
Yeah.
Does that appear to be the partition that you talked about?
Yeah.
Okay, and that's the doorway?
Yeah.
So that, would you agree that the jacuzzi is in another room separated by a partition?
Yeah, I said.
Yeah, that's all you gotta do is answer. I'm not trying to make you look bad enough, okay? So, you do see the bed?
Yeah.
Okay. Now, that's a very small room, correct? I mean, not going by that, but based on your memory. It's a very small room, right?
It's not huge or anything like
Right.
that.
I mean, we got photographs that the text took, so I'm just saying, I've seen that. I'm just asking you.
Yeah.
It's a very small room, correct?
You could say that.
So, well, what I'm saying is the room that you all were sitting in is no bigger than a 15 by 15 or something like that, right? If that big.
I couldn't tell you dimensions, but.
I know, I'm not asking you to, but I'd say approximately. It could be a 10 by 15, 15 by 15, all that is a small room, you agree?
Yeah.
Okay.
I'm not really objecting, but if Mr. Johnson isn't using the diagram anymore, maybe he could back up.
Sir, I'm pointing out to him, I know my courtroom decorum.
I was saying because of COVID.
I'm not gonna intimidate him.
Judge, if he didn't appear, I understand, he's using the diagram, that's fine, I just want to make sure.
But Chair, please don't interrupt me unless you have an objection.
Okay, let's proceed.
Sir, so do you see what could be the table that's in that room?
Yes.
Okay. And do you recall on direct, you testified that Otis, Mr. Coyle, was somewhere between you on the bed and in the middle of the room?
No.
Somewhere like that?
No.
Okay, where were you?
I was sitting right here on the bed.
Okay, so you're saying?
Toward the head of the bed.
Okay, let me see it. So you're saying you're somewhere right here at the head of the bed?
Yes, up here.
Up here, right next to the
right there.
right next to the table.
Tables.
Right. Okay. So you're saying that your knees, you're at the head of the bed, correct? I'm just trying to make a record, okay?
Closer,
for later.
Closer toward the head of the bed.
Closer to the head of the bed, and your knee is about a half a foot away from the table, or a foot?
About a half foot. Yeah.
Okay, all right, so we got that on the record, okay? And where would you say that Mr. Coyle was on this diagram?
I was here. He had to be about that far away from me.
Okay, so if you could take this pen and you could just mark where you were sitting and just put nice big letters with your initial on there. Okay. And where was Mr. Coyle? Could you mark where you believe Mr. Coyle was? Okay. And you indicated that, and would you agree that, where's the door?
The door right here.
Right there? Okay. For the record, he just pointed to the door being right next to the front door entry on the diagram. Okay. And you indicated that Daryl Johnson was moving around.
At first, yeah.
Yeah. Yeah. And you, go ahead. I don't mean to cut you off.
Yeah, because he was arguing with everybody.
Yeah, well,
his mother and.
Let's talk about that. But I'll go to that after. You did say he was moving around, correct?
Yeah.
Okay. And you don't know why he was moving around, correct?
He was angry, that's why he was moving around.
Well, you don't know why he was moving around. You know he was angry, but you don't know why he was moving around, right?
No.
Okay.
And you don't know whether he was trying to stay away from Otis, right?
I know that was not the case.
Well, you don't know that, right?
Yes, I do, because
How do
he
you know
wasn't
that? How
trying to.
could you know that?
Because Otis was not mad or arguing at him. He was arguing at everybody else.
Well, you can't say Otis was not mad or who was angry. That's speculation, ain't it, sir?
No, I know he wasn't mad.
Okay.
He was smiling and everything. He wasn't mad.
Right.
Yeah.
Well, he didn't appear to be scared, did he?
No.
No.
Nobody was at that point.
Well, I mean, you seem to know everything. You know Otis wasn't scared, right?
Nobody was scared at that point.
No, I'm talking about Otis. Otis didn't appear to be scared of Daryl Johnson, even though he had a gun that was open and everybody could see, right?
No, he wasn't. That's his cousin. I mean, that's his family member.
Sir, if you just answer the question.
No, he was not scared.
Okay, and you know Otis wasn't a scared type, right?
He seemed like a regular guy to me.
How long you been knowing Otis?
Few years, I guess. I mean.
Well, it matters. How long have you been knowing?
Few years.
So you don't know anything about Otis's background?
No, it's not none of my business.
I just simply asked you, you ain't heard or nothing about Otis? You ain't heard that Otis would do something to you?
No,
So you don't know Otis, right?
I just know what I observed whenever I've been around him.
Okay, look. I'm asking you for the truth.
Okay.
Do you know anything about Otis's background, of him being violent or him getting with you or anything like that?
Before you answer the question.
Objection as to the relevance of this, Judge?
I'm sorry, say again?
Objection as to the relevance of these questions in terms of the character evidence that the defendant.
Judge, I'm not gonna give away the purpose of my cross-examination. It's obviously relevant. If he was violent, it's relevant.
Judge.
That's just a general objection, Judge, to stop my questioning.
No, it's not, Judge. It's a very specific objection because.
Judge, I'll tie it in.
Judge, Mr. Johnson asked me not to interrupt him. I'm trying for him to ask him to do the same thing. Judge, certainly there is a rule of evidence that allows for the character or towards violence of a victim of a homicide when self-defense is an issue. However, there's been no testimony that self-defense is an issue in this case. All the witnesses that have testified thus far have said Otis Boyle did absolutely nothing threatening towards the defendant.
Judge, I'm object.
I'm not done.
I'm object to this. He can make the objection, but getting into the facts with a witness that is testifying, I got a problem with that.
Sir, can you please step out for just 1 moment?
Outside the court.
Yes.
You know
We're gonna pull you right back in, okay?
Okay.
Thank you, watch your step. Okay, Mr. Makepeace?
Thank you, Judge. As I was saying, my first argument as to why this isn't relevant is that self-defense is not yet an issue in this case. For that to be an issue, the defendant would have to testify that he was scared for his life. That hasn't happened yet. And I don't know if it will happen. I don't anticipate it to happen at this point. Even if through the questioning self-defense was to become an issue, what this witness knows about the victim's character for violence or whatever incidences that Mr. Johnson is attempting to go into is irrelevant because it's not what this witness knows that's relevant. It's what defendant Daryl Johnson knows that has to be admitted that's relevant. So if this witness is asked the question, do you know if Mr. Johnson knew of anything violent in Otis Coyle's past? Maybe that's relevant. But with this witness, we're just going into character evidence to slander the victim. That's my objection. I think it's valid.
Thank you. Mr. Johnson, did you wish to respond?
Well, Your Honor, I commend the prosecutor on his knowledge of evidence, and silently I've been commending him throughout these proceedings. But I have to say, he just showed me there's some evidence he don't know. And I wasn't asking about any specific acts of violence. I was basically laying a foundation for reputation, okay? Which that part of the evidence does not exclude the use of self-defense, okay? And I don't want to get too deeper into that because that goes to what my strategy or my defenses may be.
And
Obviously, he's not familiar with it because he's talking about something that I'm not even trying to do. But if he's going to tell me, and we've already had some testimony, and see, you got people listening, you got people watching, but he thinks he can just start coming in here and playing. No, he obviously doesn't know what I'm getting ready to do or trying to make my record to do. We've already had one witness, and I'm not going to speak on it, testify. She gave it up. I already got that in the record.
Okay.
And I can ask this gentleman, does he know? Has he heard? Does he have a reputation in the community for violence? Now, if he tells me that's not relevant, that has nothing to do with self-defense.
Okay.
If at this point, this is just a preliminary examination. I'm just making a record.
Okay, so over prosecution's objection, I will allow that question, but what I don't want to do is find ourselves going down a slippery slope.
Yeah.
That question and that question alone, as opposed to that question and then a string of other questions that follow.
Judge,
Can you bring the witness back?
with all due respect, that never was going to happen. And I don't appreciate me having to expound on it and him getting into that on this record, because I wasn't even going there. With one other witness, I asked one question, I got an answer, and I was done. And he's doing this because he doesn't want the testimony to come out. He doesn't know how to stop it. So he starts throwing in all these objections, relevance, this. And I got a problem with that because we talked about it and we put more on the record, and now it's out there, and I did not want that to happen. So
Garza, just one moment, I'm sorry, he wasn't finished. I was prematurely calling him back.
I'm gonna keep on moving, Judge. You don't even have to worry about me staying there.
Okay, so I'm sorry to go back and forth, but could you grab him one more time?
Yes.
Thank you.
Thank you, Judge.
Okay, sir, could you please retake the witness stand? And Mr. Johnson's going to pick back up with his cross-examination, okay? There was a question that was on the floor, and we did not get an answer. We paused for discussion. So could you please ask the question?
I'm gonna move on, Judge.
Okay.
You said it was nighttime when Otis arrived, right?
Yes.
Okay, you don't know who called Otis, right?
Nobody called Otis.
You don't know if anybody called Otis, yes or no?
No.
What you do know, and the only thing you know is you didn't call him, right?
Me or Quantina, no.
But you don't, okay. Now, this argument, one thing you told the police in your original statement, well, let me just ask you this for foundation. Was every last statement in this statement that you gave a lie? Or was there any truth to it?
The first statement?
Yes.
No truth.
Pardon?
No truth.
So when you told the police that you heard loud arguing, that was a lie?
Well, no. That part was true. I mean, I witnessed the argument.
Okay, so Mr. Johnson wasn't standing there arguing with himself, was he?
No.
Okay, So people were firing questions at him, right? And he was on defense firing back, right?
No.
So there was no talking, no exchange.
Everybody.
Is that what you want us to believe today?
Everybody was just trying to get him to calm down and stop thinking about the girl that just left.
That's not my question, sir. All you can tell me is what you observed, not what everybody was trying to do.
That's what I observed.
Did you observe back and forth exchange between Mr. Johnson and other people in the room? Yes or no?
Yes.
Did you hear them asking him questions about his relationship with this girl?
Yeah, they were.
Did you hear people, they didn't stand in line one by one and ask him, did they?
No.
No, people were shouting out what they wanted to ask him or what they wanted to say, and he was throwing it back and angry and belligerent, like you said, correct?
Wrong.
Well, you said he was angry and belligerent, didn't you?
Yes, he was.
So not that, wait a minute. So that ain't wrong, right? He was loud, correct?
He was.
He was belligerent, right?
Yes.
He was upset, right?
Yeah.
Because you knew that they had tricked him and lied to him and got him out the room so they could get the girl out of there, right? You knew that, right?
I didn't find that out until after the fact.
Okay, well, you didn't find a whole lot out until after the fact. But you knew today, when you said you was gonna come in here and tell the truth, you know that's the truth, correct? Yes or no?
Yes.
So he was upset about being betrayed and tricked by his mama, by Debonair, by people that he had a relationship with, right?
I guess you could say that.
You guess?
I guess you could say that.
Do you have a problem telling the truth today?
No, sir.
Okay, so yes or no?
Yeah.
And the girl left, and she left with the baby, right?
Yeah.
And you said that created a different atmosphere than what was happening prior to that, right?
Right.
Because prior to that, Daryl was calm. Daryl was, and his girlfriend and everybody was calm. No loud talking, no shouting, no anger, right?
Right.
Otis wasn't standing around trying to cool him out, right?
Right.
Oh, you remember Otis, when Otis got there, he said, take off your gun, right?
That was a while after Otis.
I didn't ask you how long ago. I said, you know, when Otis arrived, Otis said, take off your gun, right?
Because nobody else was armed, yeah.
You don't know why he said that, sir. I just want
Yes,
the answer.
I do know why.
How do you know that?
Because he said it.
Because, sir, because do you know what bias means?
Yeah.
Okay, so you a little bit of bias about Otis, right?
I'm not
being
biased.
honest, right?
I'm not biased. As far
Okay,
as-
so let me ask you the question again then. All you can tell us is that you heard, right? You heard Otis in front of everybody tell him and tell the other gentleman to take off your guns, right?
Yeah.
And they had never taken their guns out, correct?
No.
They had never threatened anybody, correct?
No.
He had never said anything to Otis, correct?
What do you mean?
Anything, sir. That's what I mean. He never said anything to Otis, threatening or non-threatening, correct?
Oh, no, he was aggressive.
Prior to him telling him.
I'm going to object because the defense is constantly cutting off the witness, and
No, he cut me off.
No, he's cutting me off. But Judge, the thing is Mr. Johnson can ask the leading questions, and he can repeatedly ask them until he gets the answer in a yes or no fashion. But the witness is trying to explain things, and Mr. Johnson has to let the witness answer the question.
I don't know what objection that is, Judge.
Improper questioning, Judge.
Okay.
Okay, so it is important, if you, the two of you, I'm gonna ask both of you, for you, counsel, to wait until he's finished answering the question, and sir, for you to not begin answering until you've heard the complete question. Okay, thank you.
Okay, so you weren't aware of any bad blood between Mr. Johnson and Otis on that day, correct?
No. No, I wasn't. I wasn't aware.
And when Otis arrived, you didn't see Mr. Johnson attack Otis or threaten Otis, correct?
Correct.
And the two men that were armed, nobody told them to remove their guns prior to Otis getting there, right?
No.
And even you, being the man of the house, per se, you didn't ask them to remove their guns, correct?
No.
And you don't know how that made him feel, correct?
No.
That's accurate, right?
Right.
And even when Otis said, remove your guns at the first time, you remember how many times Otis asked him to take his guns off?
Yeah. Yeah.
At least 3 times, right?
No.
2 times.
Twice.
All right.
The second time he shot.
Okay. But the first time he told him to take his guns off, he didn't shoot, right?
No, because he was still arguing.
Okay. And he didn't threaten Otis then or even comment on the gun, did he?
No, he was still arguing off.
Good. But he didn't comment on the gun, right?
No.
And we agreed it takes 2 to argue, right?
Yeah.
So he wasn't arguing by himself, right?
Correct.
And do you recall Otis walking up to him while he was drinking, right? Right? You say Otis was drinking, right?
Yeah, we were drinking.
So Otis walked up to him. Do you recall Otis at some point holding his arms out, telling him, show me how you bruised her?
No.
You don't remember that?
No, that did
Okay.
not happen.
Okay. Well, you didn't see everything that happened, did you? You
like
saw.
you said, the room was not huge, and
So-
everybody was sitting, or basically standing and sitting in like a circular.
Right.
So
My question is, you didn't see everything that happened, yes or no?
I saw everything that happened.
Okay. And decided not to tell the police nothing the first time?
Ask and answer, Judge.
Objection sustained.
So you agree that during that short period of time, it got heated in that room?
After the girl was gone, yeah.
Okay.
As far as on
And the
his-
girl was gone. They came back, you said, in your words, shortly after she had left, right?
Yeah, not too long after she left.
Right. So this change of atmosphere is suddenly changed when he came back, correct?
Yeah.
Okay. And in that period of time, in that short period of time, that the atmosphere changed, that's when the arguing and the loud noise continued, and you became concerned about even being put out the room, and you were trying to calm things down yourself too, correct?
We all were, yes.
Everybody was, right? So everybody had something to say. Right?
Everybody was just saying, calm down.
Everybody, I didn't ask you what everybody said. I just said everybody had something to say, right?
Not really.
Okay.
Because he was only arguing with two people.
Make sure that you listen for a question. And then if you don't hear a question, just wait for the next question.
Well, sir, you keep wanting to inject the word argument. Okay, I got that. But you trying to tell me, and under oath, that there was only two people that asked him questions about his relationship with the girl? Can you tell me what two people that was?
He was mainly arguing with Quantina and Deb.
Okay. But whoever he was arguing with, it got loud, right?
Yeah.
And then, out of nowhere, Otis asked him to take off the gun again, right?
He asked him both times right then, back to back. He asked him to take the gun off his hip because he seen he was arguing with everybody and he didn't want nothing.
You can't explain, sir, why he did it. I'm just asking you what you saw.
Okay.
Did you have in your mind you was gonna come in here before you testified and you was gonna testify a certain way? I'm asking you.
No.
Honestly. So, whether he asked him immediately or whether he asked him in the intervals, I don't know. But he asked him the second time, and that's when he, out of nowhere, pulled the gun out and shot him, correct?
Yes.
Okay. And it was like an impulse. It was like he just pulled the gun out and he shot. Objection to what?
If I may explain, Judge, speculation as to him saying it was like an impulse.
No, Judge, impulse is a word. I'm asking him, you know what an impulse is?
Can I get a ruling on the objection, Judge?
However, this witness cannot testify as to what impulse that your client may or may not have had, so the objection is sustained.
Hypothetically, sir, you know what an impulse is?
No, explain it.
I kick you in your knee and you say, ah.
Okay. All right. Yeah, I know what impulse is.
I'm saying with respect to the quickness. He asked him to take off his gun and he pulled it out, said something, and shot him, right?
Yeah.
Okay.
Yes.
You didn't see that coming, did you?
No.
Okay. And Mr. Coyle was a matter of feet away, right? I'm not gonna ask you to speculate on whether it was 4, 5, 6, but we know it was in that small room. But Mr. Coyle was somewhere in a matter of feet away from him, correct?
Yes.
Were you looking at, did you see what Mr. Otis was doing before he pulled the gun?
Yes.
Okay. Did you see what he was doing before Otis told him to put the guns down?
Yeah.
All right, Judge, I'm gonna finish up. When you say you put your hands up, right? Right? He didn't threaten you, right?
He pointed the gun.
Verbally, I'm sorry. He didn't threaten you verbally, right?
No.
Okay. You said he waved the gun, right?
Yeah.
Okay, so which one do you want us to believe today? Whether he waved it or whether he pointed it?
He aimed it slowly at everybody in the room to keep everybody from moving.
But that's what you think he wanted to do?
That's what I did.
But all this happened in a split second.
That's what he did.
But everything happened in a matter of seconds, right?
The shot was a matter of seconds. It took a little bit longer before he was all the way gone out of the room.
Yeah, I'm not talking about when he was gone out the room. I'm talking about from the time that Otis told him the second time to put the guns, take the guns off and place them somewhere. And the time that he pulled and made a statement, pulled it, shot him, waved at him, or did everything, all that happened in a matter of seconds, correct?
It felt much longer, but I guess yes.
Okay. And it was all during the height of this arguing or him complaining and belligerent, making noise. It all happened together, correct?
Yeah.
Yes?
Yes, basically in steps, yes.
Excuse me?
Yes, in steps, yes.
Okay, nothing further, Judge. Thank you.
Redirect?
Very good, Judge. Thank you. How far would you say Otis Coyle was from Daryl Johnson when Daryl Johnson shot him?
About 6, 7 feet.
I'm object to the speculation.
Can you say what distance you believe it was?
About 6 feet.
When you say about 6 feet, when you use that length, that term about 6 feet, that's what has Mr. Johnson's concern.
Okay.
Mr. Prosecutor? do
Judge,
you
if I
want
may
to-
do a small demonstration.
That's what I
Judge, we
was
got
going
a
to,
diagram where he marked it.
that's what I was going to ask you.
This is your exhibit. Why don't you use the diagram?
To be fair about the diagram, Judge, well, one, I present my case in however I choose, and the diagram says not to scale on it, so in
Well,
terms of.
that, I was just going to ask you to do
Yeah.
precisely what you're getting ready to do.
Thank you, Judge. Mr. Royston, stop me when I'm as close, if you're Daryl Johnson, stop me when I'm as close to him as Otis Coyle was, okay?
Okay.
You understand?
Yeah.
All right.
About right there.
Okay.
Right there, yeah.
You want to estimate how many feet, Mr. Johnson?
You go ahead.
I would say that's about 6 feet, Judge.
I would agree,
I think we're all familiar with that distance too.
yes.
Okay, thank you, Mr. Royston, just so we're clear on that. Mr. Johnson asked you questions about the conversation you and I had before you came into the courtroom. Do you remember that?
Yes.
Did I tell you what to say?
No.
Did I tell you to say the truth?
Yes.
Oh. Did anybody else you're also asked questions about conversations between your initial statement and the second one at headquarters. You remember those questions?
Yes.
Did anybody in your conversations tell you what to say?
No.
Did anybody tell you what not to say?
No.
All right. And going back to your initial statement, you said that that was approximately 30 to 45 minutes after the shooting, correct?
Yes.
When you were giving that statement or in the course of the aftermath when the police were on the scene, did you ever see Mr. Johnson come back to the scene?
No.
Okay. Mr. Johnson also asked you a question about the defense counsel. They have the same last name, so it's somewhat confusing. I apologize. Mr. Bertram Johnson, the defense attorney, asked you questions about his client being tricked by the people in the room, correct?
Yeah.
Do you remember that question?
Yeah.
And Mr. Bertram Johnson asked you that his client was upset about that, right?
Yeah.
Was he upset? Was one of those people in the room that he was upset at Otis Coyle?
No.
Okay. He did shoot Otis Coyle though, correct?
Yes.
All right. Now, going to that, you said that Mr. Johnson, Daryl Johnson that is, was arguing with mainly two people.
Yes.
Who were those people?
Quantina and Deb.
What was he saying towards Quantina and Deb?
I can't remember exactly word for word, but he was upset at the fact that they had let her leave and why didn't they stop her from leaving? And they were saying, we can't stop her. She's a grown woman. We can't hold her against her.
Object to what they said.
Objection sustained.
Well,
wait for my question, sir. So when Daryl Johnson was arguing with Deb and Quantina, was Deb and Quantina's, without saying what they said, were their voices raised?
Toward the end, yes.
Okay. And towards the end, meaning when he shot Otis Coyle?
I'm object to the leading nature of the question. He answered the question, Judge.
Objection sustained as to leading.
What do you mean by towards the end?
Right before he shot him.
Okay, thank you. At any point, did Otis Coyle's voice become raised?
No.
Before Daryl Johnson shot Otis Coyle, did Otis Coyle make any threatening motions towards Daryl Johnson?
No.
What did he have in his hands? Yes. Otis, that is?
Otis had a cell phone in one hand and a drink in the other.
And in terms of when Daryl Johnson learned of his girlfriend leaving him and when the shot was fired, how long in between those two times?
I'm object to the speculation.
I'm gonna say.
Well, hold on. If you know the answer, the question can be asked and answered. If you don't know, then.
Well, I was thinking, I want to give an approximate time, like you keep saying, like about all this.
Yeah, objection is overruled.
I'll say 30 minutes.
30 minutes.
30 minutes. I didn't get the question.
I'll ask the question again, Judge. Between the time that Daryl Johnson learned of his girlfriend leaving him and the time and the time that the shot was fired, how much time between those 2 points?
Between those 2 points, I'll say 15 minutes.
Okay, thank you, sir.
I'm still object to the record of speculation.
Objection noted.
May I have one moment, Judge?
Yes.
And in those 15 minutes, how would you describe Daryl Johnson's demeanor from the beginning towards the end?
Angry.
Okay. Did he get more angry as those 15 minutes went on?
Yes.
Nothing further.
Any follow-up?
So you're saying at no time did he calm down, right?
No.
Nothing further, Judge.
You may exit the courtroom. Thank you, sir. Any further witnesses?
Just gonna wait for the witness to leave the courtroom. People have no witnesses at this time.
Mr.
Nothing
Johnson,
for the defense, Your Honor.
is there a motion?
Yes, Judge, the people would move to bind over as charged, and unless the court has any questions, I would reserve argument for rebuttal.
Mr. Johnson?
Just 1 second, Judge.
Sure.
Judge, I was gonna reserve my, argument for, circuit court, but I will go ahead and make an argument now because, I believe the, evidence shows that, it's as bad as it seems, these facts do not rise to the level of, premeditation and deliberation. I think the prosecution has failed in its burden. And briefly, the reasons why is because the prosecutor has unsuccessfully tried to inject time into this record, and time and feet and conjecture. He's asked the witnesses to speculate, and but he hasn't presented a scintilla of evidence that supports that my client deliberately, with the intent to kill, premeditated, thought it out, deliberated on it, or had a plan, or had a design, or walked around that room, went out that room, or came back in, and shot Otis. There was no bad blood, no evidence of bad blood, no words of violence spoken, no threats, no prior contact. Otis wasn't even there. What the evidence shows is that my client came with his girl and a baby. Everything was good. Everything was calm. In between that time, we don't know any reason why he would be deliberating or thinking about harming Otis. He had a gun. His friend had a gun. There's been no testimony at any time that he was puffing or that he was intimidating or that he did anything that would cause one to believe that he was going to shoot Otis. And I'm just summarizing, Judge, because I know you have good notes. But based on what I'm arguing, Judge, then we see that some go out to the truck, some are in the room, but they concoct this way of assisting the young lady to get away from it. So they come back into the house. And the plan is to have Otis and take them to the store and bring them back, and then they can get her out of there. There was a lot of testimony about what she showed and showed them and all that. I don't think that goes to, for probable cause purposes, anything. What it does show is that there was a plan. And when he came back, they surprised him with that plan, which goes to his state of mind. He became upset, which goes to his state of mind. There was arguing, loudness. It became an affray. I mean, it was in that split second, it changed. He felt betrayed, and you had the testimony of other witnesses, Judge, who said that's what they gleaned. And you have witnesses, even Quantina, that said Otis arrived later. You have witnesses that even said, I think his mother, Quantina, testified of her knowledge of Otis's violence and that he was violent. At any rate, the evidence shows that there was no beef between him and Otis. My client was moving around the room. We don't know why. We don't know whether it was because he was fearful of Otis. We don't know. We can't speculate. But what we do know is, Judge, that even based on the testimony of this last witness, he said the arguing, the heat, the affray went on to seconds before the shooting. He said that it continued. And the heat of passion, Judge, was there. His baby was gone. His woman was gone. His mother, who I got her to say they didn't have a normal relationship. He already had a strained relationship with his mother. And whatever little bit he had, she betrayed him. She was on their side. They were asking him about his relationship, bruises. See, they're not telling it all, but this court can use its common sense. They wanted to bring in, this girl was bruised, this girl was this girl was, they want this court to believe that that's what he did. But we can take that truth and we can use it for what it is, Judge. Whether she told him that or not, that's what the fray arose out of. This trickery, the hurt, the pain that they left. He felt betrayed. She took the car, she took the baby. And so we know from that, Judge, that he's in a different state of mind. And so what happens is, Judge, and finally, he asked him to take off his gun. He approaches them. My client is standing there, and I could have went further and made him place where my client was, but my client was moving around. This is not a trial, but for purposes of probable cause, I left all that out. But what I did want this court to see was that you can't find premeditation and deliberation from that. In Nye versus People, 35 Mish 16, 1876, as far back, that was quoted in Vail, 393 Mish at 473. Tilly, 405 Mish at 4445. These cases have long established that there is no murder if death occurs during a sudden affray. And I don't see where he had any reason to deliberate on or premeditate to shoot and kill Otis Coyle. When Otis came anywhere near him, based on his knowledge or perception, if he was known to be violent, yeah, that could go to a self-defense claim maybe. But like the prosecutor said, we're not at that point. We don't have his testimony, but what we do know is that he pulled the gun out almost like impulsively, Judge, before there was the opportunity to cool off, before he was able to go out and people cool him off. The last witness said it all. It happened all in the moment of moments, in seconds. He impulsively pulled the gun and he shot him. And I say, Judge, that there was no moment for calm reflection. And the cases say it would be a perversion to try to apply premeditation and deliberation where the defendant acts on impulse. It doesn't matter when you look at you can apply inferences in this area. And he shot him one time. I don't think he had an opportunity to think about it. I don't think he had an opportunity to evaluate it. I don't think he had an opportunity to take a second look. And if he did, the opportunity must be adequate, but it not need be long. I just don't see it, Judge. And I think that we're talking about something, and I'm going to cut it short. I think we're talking about something like manslaughter. The element of malice, the kind of malice that premeditation requires, I don't think was there. I think something snapped. And it's basically reasons called provocation.
Thank you. Before you proceed, Mr. Makepeace, I just want to make sure that we're honing in on precisely what the argument is that's being raised by the defense. The crux of his argument, obviously, is that you have not established by a probable cause standard the premeditation aspect. So that begs the question, how much time or how little time in the eyes of the law is required to establish by a probable cause standard that intent to kill?
Well, Judge, in terms of if we're speaking of time, the law doesn't give us a time. The jury instruction very clearly says that the amount of time is ultimately a question of fact for the trier of fact. And in terms of, I understand the court wants me to focus in on the premeditation deliberation element. What Mr. Johnson is trying to do is something that the jury ultimately is going to have to do. Mr. Johnson is trying to limit the time, for lack of a better word to describe it, split time. He wants the jury, or you in this case, to only consider the time after the gun is pulled. But certainly we have a lot of information and evidence regarding what happened before that time. For example, Judge, we know, as Mr. Johnson pointed out, that there was a plan to get this girlfriend away from him, and that he was upset by that. The jury could very easily infer that that's when the premeditation deliberation starts. There's testimony to say that shows that he was getting angrier and angrier and angrier. There's testimony from Devonine Tutstone that she said that he seemed to be, that being the defendant, seemed to be angry at everyone in the room. And certainly, it's a fair inference for the defendant to think that Otis Coyle was in on that plan. But ultimately, Judge, all of this that we're talking about is a question of fact for the trier of fact, whether he had that state of mind, which states of mind generally are questions of fact for the trier of fact. And one last thing, Judge, in terms of Mr. Johnson did mention manslaughter and words like heat of passion. I just want to touch on that very briefly because the case law on that is very clear. I'm just going to read from, I believe it's a Michigan appellate case, 1991, People v. Pouncey, 437, Mishap 382. Just quoting it, or summarizing it, I should say, provocation must be such as to cause a reasonable person to lose control and act out of passion rather than reason. In general, insulting words are not adequate provocation, which is all that we have. No testimony of any actual action, physical action towards the defendant or anything like that. Ultimately, Judge, I would ask that you bind over as charged. There was no argument to the felonious assault to the felony firearms. We just talked about premeditation, and I think it has been established to a probable cause standard. And that question, that intent question, should go to the jury for the as a trier of fact.
Thank you. Thank you for your indulgence in answering that question or responding to that argument with specificity. I think it's just important to make a record when there's arguments being raised. And Mr. Johnson, it's important that you understand, sir, what the purpose of this hearing is today. This is a preliminary examination. I know that you know this because you've got an excellent attorney who I know has explained what the purpose of today's proceeding is. This is not a trial. Today is not a trial. This is an examination to determine whether or not the prosecution has enough evidence to proceed forward. And that level, that hurdle that the prosecution has to clear is called probable cause. Now, a lot of attorneys argue that they don't like how low that standard is. This is what the standard is at this level. Until laws change, that is what is required to be established. Probable cause to believe that crimes were committed in the city of Detroit and in the county of Wayne, and probable cause to believe that you were the one that committed those crimes. So coupled with the testimony that we started on a previous occasion, and Mr. Johnson is right, I take very copious notes. I've had a chance to review them before we got back on the record today. I reviewed them at the close of the proofs being put on here today, as well as taking into consideration the exhibits count, exhibits 1 and 2, I believe there was also a stipulation as it relates to the identity of the victim in this matter. And exhibit 1 was the ME's report, which articulated the cause and manner of death. So all of these things taken hand in hand with the testimony, the oral testimony that was provided on the record, not only today, but at the previous commencement of the examination. This court is satisfied that there is probable cause that has been established on all of the counts that are before the court. So I am going to bind over on all of the counts that are contained in the complaint. The matter is going to proceed on to circuit court. At circuit court is where the burden of proof rises substantially and significantly to beyond a reasonable doubt. It's a totally different threshold. And you and your attorney will be permitted rather to proceed with whatever arguments you deem are appropriate. And I'm certain that your attorney is going to hold the prosecutor to that much higher standard. The arraignment on information date is going to be the 11th, no, strike that, the 4th, August 4th at 9 a.m. Is there anything further?
Not for the people, Judge. Thank you.
Nothing further, Your Honor. Thank you for your indulgence.
Thank you so much.